Item number 1, 2, 3. Mention करेगा.
Mention कर रहे हैं. My lord.
Yes.
May I please, my lord? My lord, I beg to mention item number 3.
3.
Yes, my lord.
Item number 1, 2, and 3 are analogous matters.
On
Yeah.
behalf of
Item
Mr.
number
H. Lampu,
1,
not
2, and
keeping
3
well.
are analogous matters.
So we are aware about that. See, Mr. Counsel, have you seen the cost list?
Yes.
These 3 are clubbed together. You mentioned only one item. You want it to be segregated, or what?
Yes, ma'am.
What do you mean, yes?
If I may,
Without-
Lordship, I will also break item number 1 also. My senior Mr. Rintu Sakia is out of station here.
On the last occasion, they have shown urgency, and they have, since we were not present, somehow they have shown urgency and they were opposing our prayer for adjournment. Today we are ready, my lord. They are asking for adjournment. They themselves have fixed this date, man.
So what is new? This is going on. Next day you'll be ready, other side will not be ready. Like that.
Since my senior is out of station here, Lordship.
So what to do? Then you argue. Let him be out of station, you argue.
Yeah.
No, your Lordship, I'm not.
Being out of station is not a ground for adjournment.
So my,
He has some personal.
Your Lordship. my senior is also not keeping well. Mr. H. Lampu.
So you come to a consensus. When do you want all?
Well, there is some
Mr.
urgency in the
Majumdar,
matter. Madam Mr. There is some urgency in the matter. We are also accountable to our clients, my lord. Some they pray for adjournment and we are unable to answer to our clients, my lord. My juniors are pressing very hard that we should not concede for their prayer for adjournment made by other side. My learned friend, Mr. Panging, is also there.
Okay.
He's
If there is
also ready.
urgency, all of you agree to a date. All of you agree to a date. Since today it might be perhaps it's not possible to take up.
Prayer is not being made by the other side. Prayers are being made by on behalf of the same. They are on the same side.
Mm.
I'm on the other
Yes.
side. I've never prayed for adjournment.
My lord, Mr. Pang is ready and he is not praying for adjournment. I am also ready.
Mm. Mr. R. Saikia and who? Who is out of station?
H. Lampu.
H. Lampu.
Lampu. Okay. Please write Mr. R. Saikia. Learned counsel appearing for the appellant in WA number 28 of 2024. When Mr. H. Lampu, learned counsel appearing for the appellant in WA number 1 of 2025, are said to be out of station, and an adjournment and a prayer for adjournment has been made on their behalf.
Lordship may kindly mention that I am opposing.
However, the same is opposed to by the learned counsels appearing for the other parties. So, considering the submission made, we allow the adjournment with an observation that the parties should not pray for further adjournment on the next date. List the matter again on.
After winter
Let it be in the manner. Well, let it be in the first week of February. Well, January, I have got some difficulties. Let it be 10th of February, my lord.
All of you agree? 10th of February?
Objection, my lord. There is no interim order against.
Okay. List on 10th of February 2025.
My
26.
learned friend, Mr. Panging, is happy because there is no interim order.
Yes. It has not even been admitted
My
for the
lord,
last 2 years.
My lord, in this case, otherwise the issue is very simple. We have been promoted from the post of junior engineer to assistant engineer with prospective effect. We are praying for retrospective effect. Learned single judge has held that there is no vacancy, whereas the government has filed an affidavit specifically mentioning the number of vacancies existing. That is the only issue to be decided in the case.
Next court date, all of you be ready.
Yes.
All right. Yes. Any other mention?
Much obliged.
Item number 4.
Please. Malat, basically, the appellant against the Malat, the impugn order passed by the honorable single bench, by which Malat, my attention was not taken into consideration.
You are the writ petitioner.
Malat.
Your writ petition was dismissed.
Yes, Malat.
I see.
Impugn order, Malat, Lordship will find it, page number Malat 609, Malat, Annexure 6, Malat.
No, in a nutshell,
Malat.
briefly, in a nutshell, what is your case?
Malat, my case is precisely NIT was issued, Malat, for which the last date has been given on a fixed date. And before that, Malat, the original document has to be produced much earlier. And when I went to the office of the Malat, the executive engineer, who is the tendering authority, Malat, I have been prevented from participating in the tender process by refusing Malat to accept my tender fees and all, Malat. That is the precise case. And he was remain absent.
You approached late.
No, Malat. On time, I approached. Despite the paucity of time, we Malat tried our endeavor to Malat participate. We tried our best to Malat participate in the tender process, Malat.
You were on time.
Yes, Malat.
You approached on time.
Yes, Malat.
But you were refused.
Refused, Malat, in the sense he was tendering authority was not remain available in the office, Malat.
Okay.
So thereafter, Malat, Malat, in the tender document, if Lordship perused the Malat, the NEIT, Malat, notice inviting e-tender, Malat. There is a procedure where Malat, the certain things has to be followed first, Malat. As per the Malat, the NIT, Malat, I have to produce the Malat, the original documents before Malat, last date of submission, Malat. Last date of submission is fixed on Malat, the
Physically, you have to-
physically, Malat. It has to be Malat first produced.
physically, you have to produce before the authority,
Correct, Malat.
before the last date.
Much before the last date, Malat.
And did you produce?
Yes, Malat.
But they were not available.
Not available. Therefore, Malat, my NIT was not processed further
I see.
for Malat, the parties tendering process, Malat. The Malat, two bid systems, in such two bid systems, Malat, first is technical, second is financial, Malat. In the technical, even before the technical, Malat, date of scrutiny, Malat, my NIT has been rejected, Malat. Much earlier, Malat. And for this short period, Malat, we approached to the higher authorities, that is, Malat, the superintending engineer, Malat. The superintendent engineer, on receipt of my representations, Malat, further extended the time for Malat, the last date of submission, Malat. That has also not been taken into consideration, Malat. That is all are available on the record, Malat.
So what did the learned single judge say?
Learned single judge, no, you have been already rejected.
Oh.
Malat, they are invoking one clause, which is not at all, Malat, Malat, specifically not mentioning anything, Malat. What they have done is, Malat, on third, Malat, before the last date of submission, even before the Malat, this date of the scrutiny for the Malat bids, Malat, my tender has been rejected. And they are saying that, no, your NIT has been already, Malat, the bids has been already rejected. Therefore, your case was not further processed, Malat. And they are saying, again, they are contending that rejection order has been duly communicated, which we are refuting, Malat. We have not received any documents, and that even if it is, Malat, even if that documents is considered to be, Malat, true and valid, Malat, still then, Malat, that is much before the date of scrutiny, Malat. Date of scrutiny is fixed on, Malat, 14 July 2025.
What you are saying is that before the scrutiny date,
Correct, Malat.
your tender was rejected.
Yes, Malat. And on, Malat,
Is that in terms of the NIT?
Malat, NIT, Malat, some,
See,
Malat,
only if your bids are correct in proper shape, then scrutiny will take place.
Yes, ma'am.
scrutiny will, Malat, scrutiny, Malat, my respect commission.
Mr. Kato,
Yes, Malat.
see, if your tenders are in proper order,
Yes, Malat.
then only they'll scrutinize. Supposing they are not in proper order, can they not reject it?
Matlab, to my
And if they reject it, where is the question of
Matlab, there is,
processing it?
of course, matlab, there is matlab, one clause in the matlab, central matlab, the CPWD manual, matlab,
Hmm.
wherein matlab, the curative can also be done during this period, matlab. And that even opportunity, even if there is matlab, considers to be matlab, the bailey, then through matlab, if my rejection is matlab, still then there is a matlab, the procedure for matlab, the correction and the
All
rectification
right,
of the,
we'll come to that. We'll have to see the terms and conditions of the tender
correct,
document.
matlab.
You say this is e-tender,
E-tender, matlab.
but still you have to go physically and produce.
Well, that is a technicality is how to divert me, Malan, from participating in tender, Malan. Just
No,
terms,
you are not alone. There are others also.
others, Malan, the others are, of course, Malan, they have chosen
Your
already.
case will be that you are singled out.
Yes.
Their case will be that there are so many people who could participate.
We never came
Who is he who
across,
cannot furnish his own documents in time?
Malan,
They will say that.
in every tender, Malan, we never came across such stipulated conditions wherein, Malan, the shorter period has been fixed, whereas the longer period for the, Malan, the submission of the online bidding. Malan, this is another irony. Of course, Malan, that is how to, Malan,
So now there's an interim order.
Malan.
What is the interim order?
Interim, Malan, not to finalize till that, Malan.
Not to finalize.
Yes, Malan. In fact, on the last occasion, Malan, his lordship for the Malan.
That's why I think the additional age is in a hurry. Isn't it?
Yes, Malan.
So now let's get to the documents.
Yes, Malan. And the last occasion, Malan, his lordship, Malan, the call for the records. What they are, Malan, projecting is, there is a special terms and conditions, which is, Malan, the entire documents is not enclosed. Of course, Malan, not, Malan, that bid documents is bulky, but I don't know whether record has been received or not. Malan, on the last occasion, Malan, the record was called for, Malan. And the Malan, record to be verified, to that extent, Malan, whether there is a, Malan, the special terms and conditions that stipulates, Malan, certain things has to be followed first, Malan, and that, Malan, documents which they require to be verified first is also not, Malan, the required to be, Malan, complied with, Malan. It is, Malan, admittedly a firm, Malan. So therefore, Malan, may I take your lordships to firstly the impugn NIT, Malan. Malan, basically in the writ petition, Malan, we prayed for the, Malan, the press issuance of NIT, Malan, so as to give the opportunity to every, Malan, the intended tenderers, Malan. That was our basic, Malan, the prayer. Even if, Malan, the fresh NIT is issued, they will be not barred, Malan. Whosoever interested, Malan, that equal
Mr. Pato, let
Yes,
us see the facts first. Then you come to the submission later on.
Malan.
Tell us the facts.
Malan,
This point, that point, this is what has happened.
Yes, Malan.
And lastly, the submission.
Correct, Malan.
Yes,
May I take your lordships to the, Malan,
NIT.
impugn NIT, Malan. It is in page
58.
number, Malan,
58.
58, Malan.
Hmm.
Malan, may kindly, Malan, see date when the NIT was Malan, published. It is 30th, Malan, June 2025, Malan.
Hmm.
Malan, the executive engineer, Yamsa PWD, I'm reading on, Malan, on behalf of the governor of Arunachal Pradesh.
NIT is 56. This is
I'm reading on 50, Malan, the 8, page number 58, Malan.
this is IFB. IFB. 58 is IFB.
NIT is 56.
56.
Yes, Malan.
Date is the same otherwise.
Yes, Malan. Same, Malan. This is press, Malan. In press, Malan, publication, entire things are not given, Malan. First one is press release, Malan. Page number 56.
58, you can,
58, I'm on 58, Malan.
Right.
It is, Malan, more detailed. The executive engineer, Yamsa Division, PWD, Arunachal Pradesh, on behalf of the governor of Arunachal Pradesh, invites, Malan, online item rail e-tendering in double bid system from registered and the eligible contractors in class 1, class 1A, class 1AA, BNR category in APWD, so and so, Malan. The name of, Malan, in table, name of work, serial number 1, NIT number, Malan. Third box, Malan, name of work and location, Malan. Upgradation of Yamcha ADC headquarter to Lirmoba EAC headquarter road under so and so, Malan. The estimated cost is also given, Malan. Period of completion, Malan. just serial number 1, madam. The period of availability of online bid oblique date and date oblique time of online bid systems, bid submission, and the date and time of the openings of the bids are given as under, madam. Madam, availability of the tenders online for the bidders from 30th to 30 June 2025. Madam, second is to 14 July 2025, madam. And start time, madam, is also given, madam. Now, madam, terms and condition, madam, I'll skip 1, 2, 3, and 4, madam. Start away, madam, clause number 5, madam. This is the, madam, difficulty by which, madam, they are trying to impose upon the other tenderers, madam, intended tenderers.
Before that, this double bid system means that
Financial as well as, madam,
technical and
technical as well as
financial.
financial.
Okay. Number 5.
Yes, madam, number 5. The bids can be deposited before the time is specified by paying the cost of the bidding documents, non-refundable in cash of Rs 10,000, rupees 10,000 only, with the EMD, madam, earnest money deposit, and other original documents to the executive engineer YAMSA PWT division AP from, madam, they have intentionally, madam, made bold in letter from 30th June 2025 to 5th July 2025, madam. Madam, this is the, madam, the difficulty, madam. Last date of submission, a bid system is on.
Yeah, that's fine. They're asking only for the EMD.
Yes,
That
madam.
may be a special condition.
Yes, madam.
And that hasn't specified there.
No, madam.
specifically.
Madam,
Not entirely.
bidding madam, the uploading documents,
No, that can be a special condition. There's nothing in that. Is there any bar on doing that?
madam, difficulty is all entire documents has to be prepared first, madam. In tender system, madam, entire documents has to be prepared, madam. Some documents has to be also collected from the different offices, madam. So therefore, madam, the bid system, madam, what the, madam, original document has to be done first is, madam, that we have also complied with, madam. Though there is a shorter period, madam. And, madam, accordingly, madam, we, madam, downloaded the entire documents and madam, prepare our documents, madam. Thereafter, madam, we,
No, see, what you are trying to say is that this date is from 36 to 57,
yes, madam.
whereas in the serial number 1, online submission date is 1/7 to 14/7.
Correct, madam. Correct, madam.
You're saying that this is shorter.
Short-term, madam.
In the box, it is given up till 14/7.
Correct, madam.
Here, it has been restricted to 5/7.
Still then, madam, that is another, madam,
When did you try to submit your?
on
when-
3rd July 2024, on 4th July 2024, as per their, madam, serial time, madam.
Third and
Even still then, the executive engineer, tendering authority, he remained absent from the, madam, office.
3rd and 4th July.
Yes, madam. On time, madam.
Was Thursday
Whereas
and
last date
Friday.
is on 5th, madam.
Thursday and Friday.
Thursday and Friday, madam. Even on 5th, he remained absent. Even on 6th, remained absent. Madam, entire tender period, he remained absent, madam.
Okay, please carry on.
Yes, madam. And madam, exactly, we have prepared the documents, madam. The lordship knows that EMD is one of the, madam, the important documents, madam, by which, madam, the tender cannot be processed further.
Earnest money deposit.
Yes, madam. And that was prepared in the name of, madam, the executive engineer on 2nd, madam, 2nd July 2025, madam. It is, lordship will find at page number 80, madam. Other documents are available with me, madam, in respect of, madam, the PAN card, Aadhaar card, and other documents, registration, contract registration certificate. But only thing is that, madam, this amount, madam, lordship has seen the estimated cost of tender, and, madam, for which, madam, the calculated amount comes to, madam, 39 lakhs for 70,000, madam. Page number 80, madam, I'm reading, madam.
Hmm.
This was prepared on 2nd July 2025, madam. After this preparation of, madam, the entire documents, my precise case is,
No, what is the date of preparation?
madam, it is that in Belu, madam, it is in second last column, madam.
There's a column for date on the top,
Yes, madam.
right hand side, but it's not blank.
Copy is missing. Nothing is there.
It's blank. The value date is 2/7/25. Then maturity date is also 2/7/25.
Yes, madam. Value date is, malad, it starts from, malad. This is the, malad, the bank copy.
Is it supposed to be like that?
Yes, madam.
Value date and maturity date.
Yes, madam. And in fact, malad, this is not disputed, malad, that part, malad, this is not the ground for rejection, madam.
Maturity date should be same date.
Same day they are supposed to give it probably. That's why for 1 day only it has been given.
Malad, this is the bank documents, malad, which we are not, malad. Malad, kindly see when it was submitted, malad, it is just below, malad, in Bank of India, just below, malad. Just symbol, Badri Rai and Company, top above, malad.
No, that's fine. Like, we are just little bit confused with this. I mean, value date and maturity date. What does it mean actually?
Both are same.
Malad,
No,
value
what
date,
does it mean? Maturity date means what?
maturity date is, malad, maybe, malad, it has been wrongly prepared. Actually, it has to be,
Is it so that like after, if you submit this document post 272025, it's invalid?
no,
Like
malad.
that? Then
Even-
why the maturity date is there?
Malad, maturity date, how this has been prepared, this is the bank documents, malad. We,
Correct, but like you have to have the answer of this. Correct.
malad,
Is that-
my respectful submission is, this is wrong date, malad. It has to be 2026, malad.
So if they reject on this ground, then you are also agreeable.
Malad.
If they reject on this ground, EMD is not an
Malad.
order,
Malad, that part,
then you
malad.
have to accept it.
Yes, malad. But malad, irony is, my ground,
See, you are submitting this for EMD, right?
yes, malad.
So EMD is valid for certain period of time
Correct,
usually.
malad. Till the, malad, the subsistence
So
of the contract,
as
malad.
you have said,
This will be, malad, valid,
it should
valid-
be valid for a year, 2 years, something like that.
correct, malad.
Correct.
Till the, malad, the subsistence of the contract agreement, malad. This
That's
will
what-
be,
So like so the same date
yes, malad.
it cannot be.
Period of completion is 24 months.
Correct, malad.
It should have been valid for 2 months, 2
months.
years.
Malad, that aspect, malad, malad, I'm sorry,
Date
malad.
we have
My
found
respect-
already, it's there, date 2/7/2025 on the top.
Yes, madam. My respectful submission is, malad, if such is the case, malad, the ground of rejection is not on this point, malad.
Correct. That we understand.
Yes,
we
ma'am.
understand.
Okay, not on this point.
Not on this point.
That's okay, then let's not waste time on this then.
And this can be also, malad, rectified. There is a procedure for the rectification of the
Alright.
deficiencies, malad.
If this is not ground for rejection, it's all right.
Malad.
Now,
Now, malad,
Next.
I went to the office of the, malad, executive engineer with entire documents, malad,
Hmm.
regarding this, malad, original documents, EMD, malad, and the other documents, malad. I went to the office of the, malad, executive engineers to show my original documents on 4th July 2025, malad. As I have pointed, malad,
So no one was there.
Ye-
So you filed a representation.
two official whom, malad, work was assigned to receive the documents were there, malad.
Hmm.
And by order, malad, they have engaged 2 junior engineer to receive, malad, that assignment was given to the 2 junior engineer, malad.
So then what is the point of him remaining absent? Has any grievance by you?
Malad, the 2 officers, malad, just may I take your lordships to just to clarify that, malad, lordship query. It is in page number 70. Official order, malad. In fact, office order was issued.
Yes, these 2 persons have been
Correct, malad.
Authorized.
authorized.
2 persons, malad. Now, this, malad, what these 2 persons has said is at page number, malad, again, page number, malad. Page number, malad, 92, malad. Type copy is 93, malad. These 2 officers has said that, yes, of course, we were defeated for the receiving of the certain documents and the tender paper, malad. But then that was not processed further due to, malad, the approval from the authorities, malad. Higher authorities, that is executive engineer, malad.
Page
Type-
92.
Correct, malad.
93 is type copy.
Type copy, malad. what they are diffusing is, by this Malad, we internet tenderer pressurize him, why you are not processing, Malad? And out of that, Malad, he has to give in this statement that but due to Malad, last person, but due to absence of the concerned authority, the person assigned for the receiving and the forwarding the applications could not provide us with the said application, and that is why we unable to receive the processing fee and the EMD from so and so, Malad. Two firms were Malad made attempted for submission of the documents, Malad.
Your firm?
I am for the Badri Rai, Malad. Badri Rai and Company, Malad. First one. And the second is, Malad, the page number 94 is the handwritten, Malad, type copy is page number 95, Malad.
What is the application they are talking about?
Worship
In page 93, what is the application?
application, Malad, that application, Malad, for participating in the tender process, Malad, we come with the basically, Malad, the forwarding letter. Yes, I'm the internet tenderer. I'm forwarding here so and so, Malad. That application, Malad. Of course, Malad, admittedly, I have not annexed in my
There is a format like that.
format, not exactly, Malad. It can be directly handed over also, Malad. But there is no restriction on that part, Malad. In
In
the
the
tender,
documents.
there is,
there.
yes, Malad. There is no whisper about the terms and conditions in the, Malad, the condition of the
My lord,
contract.
exactly it's like this, my lord. Every farm owner, they'll write in the pad, authorizing if someone is representing that I'm authorizing Mr. X and Y, my lord, to
Submit.
submit this document so that the process could be started. So in their registered pad, they have to submit, my lord, addressing to the executive engineer, my lord.
But in the instant case, what happened?
They have submitted, but not the original one. The EMD, they have not submitted the original one, which is mandatory. Then PAN card, other cards, my lord, these are mandatory as per clause 26.
Why these people did not receive it? I mean, they said some application is not there.
My lord, they are not saying, my lord, that they have not received. They have received, but it will be forwarded to the executive engineer for their approval, my lord.
Not processed, Malad, processed.
The process is different, my lord. To process, my lord, they have to, my lord, give all these original documents.
See, grievances on
Unable to receive
whatever I could
processing.
understand. The grievance is only that these documents were not received in time, correct? They went to the, I mean, deposit,
No.
but it was not received. And these two people have refused it with certain, I mean,
Observations, my lord.
observation.
No, that is not correct, my lord.
Hmm.
They have received, my lord, they have received the whatever document they have submitted, it was forwarded to the executive engineer for further verification, my lord. Then the executive engineer, my lord, who is the authority, found that, my lord, they have not submitted the original EMD, my lord.
Correct.
That is the
Okay,
point, my lord.
understood.
That is the reason, my lord.
Yes.
Malad, that was not processed, Malad, as I have pointed out, Malad. My submission, Malad, precise submission is, I went to the office of the Malad, the executive engineer, to submit these original documents that has not been received. They refused to receive, and due to that non-receive of the original documents, that
Where
was
is
not
that
processed.
from? Where we can find that?
Malad, of course, Malad, when they have refused to receive, Malad.
No, I mean, what you are submitting, that they refuse to accept those documents. Where is that?
This is the document, the statement given by the Malad, the two officials whom the work was assigned, Malad. This is the Malad only. And Malad, having no option, we approached to the Malad, the superintending engineer.
See the original document.
See the statement here.
System is not saying that.
This Nabam also, Mr. Nabam also will take note of this fact. The statement of these two persons, it says that they did not receive that documents because the same has to be received only by them, only after the application and the tender documents have been verified by the executive engineer.
Correct, Malad.
First of all, he'll go to the executive engineer, he'll verify, then he'll send it to the
Exactly,
two guys,
Malad.
you receive it.
Exactly, Malad.
So this is what they say, I think.
Correct, that's the thing.
We cannot receive it because executive engineer has not verified.
Malad, that is the precise case.
And that is your case also, that executive
yes.
engineer was not available.
No, remain present, Malad. Malad, having no option, Malad, even we went to the higher authorities, Malad, next to the Malad executive engineer, superintending engineer, page number Malad 96, Malad.
96.
Executive engineer, by virtue of the Malad, the higher in post, Malad.
You went to the
Correlation was-
office on 3rd and 4th July.
Correct, Malad.
Then before the superintending engineer, when?
On Malad, superintending engineer on,
Page number?
it is in page number Malad 103, Malad.
But then again, if you come to page 95, they say, I have received application from MS Badri, and I have forwarded the document to EPWD Yomcha division for verifying.
But he was unable to.
Yes. But he was unavailable at division office during office hours, 3rd to 5th, due to reasons not known to me. So they have received and forwarded. It is not that they have not received it.
That was not processed, Malad.
Process is different thing, of course.
This is different thing.
It
Process
could not be
is-
processed because the executive engineer
Was not there. That
Not
much we have understood only. You gave your thing, they received it, but it has to be processed.
Not processed, Malad.
It has to be processed after the executive engineer verifies it.
Correct.
He was not there, so it could not be processed. Then now you say that you went to the superintending engineer. When?
Malad, we made a complaint to them, Malad, the superintendent engineer, in return, Malad, what the superintendent
Where is
engineer,
your complaint?
14/7/2025.
correct, Malad,
Where is your complaint?
page number 103, Malad. And even before also, Malad, that we approached to the Malad, it is 40, Malad, I'll turn back to Lordship, that page number 87 is the Malad, my representation to the Malad, the superintendent engineer.
103.
103 is also Malad, another complaint, Malad. It is
The
before
second one,
How many complaints?
two complaints.
Dated?
Dated, Malad, page number 87 is the 4th July 2024, Malad.
so 4th and 15th,
Correct, Malad.
4th and 14th.
That is after rejection and before rejection also, Malad.
Page?
Before last date or after, before last date and after last date.
Page?
Page 87, Malad.
4th July.
4th July 2025, Malad. Malad, this detailed representation was submitted to the superintending engineer on 4th Malad, July 2025. In return, Malad, what the superintendent engineer has done is page number Malad
He wrote
96.
to the executive engineer.
Executive engineer also, Malad. We approached to the Malad.
Don't
There is a
Don't confuse us. First of all, you come to page 87.
87 is the Malad representation, Malad.
Correct. Where have you written that I have gone to the office, but executive engineer is not there? You are mentioning about some clause. This is not fair, that is not fair, all that.
Yes.
Where is the thing that executive engineer was not there? My papers could not be processed.
Malad, second paragraph. Third paragraph, sir. Malad, may I read, Malad, the first one?
Read.
As per the Malad. As per the published tender schedule, the online submission period was clearly fixed on 30th June 2025 to 14 July 2004, up to 1600 hours. While with the openings of the technical bid schedule dated
It's no use. I've already told you that. You're repeating the same thing.
You read the third paragraph, bottom.
third paragraph, Malad. I'm also coming to
Hmm.
that part. However, within this short span of time, we somehow managed to prepare all documents, the processing scheme, the approach to the submit to the within this imposed the window, the executive engineer remain unavailable, Malad, untraceable, despite our several attempts to contact with throughout the period since, and two designated subordinate in charge officers, namely the assistant engineer A and the junior engineer J categorically refused to accept on the grounds that they lacks the authority in his absence. This arbitrary conduct left us with no practical means to comply, even though the online uploadings window remained valid up to 14 July 2025. This action amounts to tampering of the tender process with no reasonable justification and indicates as clear intention to disqualify us by imposing the impossible and the inconsistent condition, while allowing favor bidders to complete their submissions unhindered. But so many things has been written, Malan, but this is the party name. Malan.
What is your prayer? Read. Number one, direct.
Direct the executive engineers to modify the dispute clause requiring submissions of the original documents before 5th July 2025 and extend the deadlines to allow all the participants to submit the original documents on or before the 14th July 2025 manner. That is the date of the openings of the technical bid in line with the standard CPWD procedures and transparency principles, or in the alternative, the cancels the tenders in the interest of the fairness and invite press bids in compliance with established norms. Third, impartial inquiry may be conducted into the matters to examine the documents under which these conditions were imposed and why the executive engineer Yamsa divisions remain untraceable, effectively denying us the right to participate. And your prompt actions will ensure the the equal opportunity for all the equal eligible bidders.
No, Mr. Kato, like let me just clarify one thing.
Malan.
I mean, if you come to page 95,
Yes, ma'am.
see 95. I mean, this is a letter, correct?
Yes, ma'am.
So this is a letter wherein these two persons who have been authorized to receive it,
Malan.
they have written that they have received your document, correct?
Yes, ma'am.
And whereas in page 47, what you have written in your representation, you have stated categorically that they refuse to receive it.
Malan.
Now, which is the correct thing? I mean, see, in 47 letter, you have stated that despite our several attempts to contact him throughout the period since so and so since, and two designated subordinate officers in charge, namely so and so, categorically refused to accept.
Malan categorically refused to accept the original documents, Malan.
But
Of
that
course,
hasn't mentioned here.
it has not been stated everything, Malan, but original documents has to be produced first, Malan. Malan, in the beginning, Malan, it was my submission, Malan.
In your in that page 95 letter also, they
Yes,
mentioned about anything about original or
Madam.
duplicate.
Madam.
They simply stated that the application has been received and that has been forwarded. I have forwarded the said documents to so and so for verifying. So non-receipt, I mean,
I have, Malan, may I read again, Malan? I have forwarded the said documents to Yamsa PW Division for verifying the reader's documents for further pursuit. But he was unavailable at division office during office hours from so and
that's
so.
a different issue. I mean, now you are alleging that the documents have not been received only in your representation.
Malan, may kindly appreciate one thing.
No.
Receipt
I
of the
mean, you
documents is
clarify this,
one
whether
thing.
your documents were received or not. Whether your documents were received by these
Malan-
two officers or not. And if you are writing that your documents have not been received, then you are misrepresenting the
Malan,
facts.
Documents is received, not the original one, Malan.
Then you haven't stated so. You haven't stated so.
Malan, that is my case, Malan. Everything is not written in this piece of paper, Malan.
No,
But then,
I mean,
Malan,
see, your basic case is that only.
Malan, head it
That
with the
you
case.
went there, that you went there, went to the office of the executive engineer. Engineer was not present, but though two authorized officers were there, but they didn't receive the documents. But whereas the document shows that your documents have been
Or-
received
Malan,
and that have been sent for processing.
Or-
But as the executive engineer was not there, probably that could not be processed.
Malan, my submission is, respectful submission is, original documents were not received. Photocopy of the documents, Malan, by which they have, Malan, the perused while rejection of the, Malan, my tender. Malan, one thing, Malan, may kindly
Okay,
appreciate.
show us your that rejection thing.
Yes, Malan.
Where
How my lord, without receiving my processing fees and my lord, the EMD, how the authorities have rejected my lord, the bid, my lord, is still my lord. How this can be processed, my lord? How this can be done? My lord, I asking myself that how this has been done, my lord, without receiving my original, my lord, without verifying my original, my lord, without processing my original, my lord.
Where do we find that you have gone with your original documents and your original documents are not received? From where do we find that?
My lord, in the,
From
Lord,
where do we find that you have gone with your original documents, but your original documents were in fact rejected, not received, and therefore you have given the Xerox copies? From where do you find that?
my lord, other than this, my lord, the representation, my lord, and the
And representative is totally silent on that.
my lord, other than this representation and my lord, this statement given by the two official, my lord, admittedly, my lord, there is no other records, my lord.
Then, I mean, then where is your case? Then
But-
where is your case?
My lord, that is the technical thing, my lord. They are not giving any other documents, my lord. They are not
Then you
even.
should have mentioned it in your representation. The original documents are not received.
Correct.
And your on the basis of your Xerox, I mean, photostat copies, they have considered your case and like then rejected it, saying that your original documents were not there.
My lord.
That is not your case. They haven't made out that case.
Admittedly, my lord, that is not been
You have
clear.
a second representation,
Second,
second representation,
14.7.
14.7. Where is that?
page number 103, my lord.
10.
3, my lord.
Let us see what you stated there.
One zero three, my lord.
Hmm.
It was on 14 July 2025, representing requesting departmental inquiry against Shri so-and-so, executive engineer, madam, so-and-so for misconducts and the procedural, the irregularities in tender, the process and so-and-so, so-and-so. With due respect, I, the understanding, they agree, the intending tender, the participant
We
wish to
come
bring.
to paragraph 3 straight away.
Madam. Though the subordinate officials, the Sri so-and-so, so-and-so, J so-and-so, and others were officially endorsed to the collect the applications and issue receipts. And the receipt has also been now mentioned. They verbally communicated that they had been instructed by the executive engineer not to receive or act on any submissions in
This
his.
is not correct. This is not correct.
This is
I
not,
mean, that you have only submitted this document along with this petition application, that letter of those two authorized officers.
14.
On the face of it, how can you say this? On the face of that letter that you have submitted,
This was
see, this is your document only.
Yes, ma'am.
You have annexed it with the writ appeal, correct? So herein it specifically says that like they have received it and they forwarded it to the executive engineer. And on the face of this letter, how can you say that like it was not received in your representation? How can you say so?
Malad, this was happened. In fact, Malad, practically it was happened. Therefore, Malad, this has been reduced in this Malad representation, Malad. Had it been Malad, there was no such
The
Malad.
representation, there is no whisper of what you are submitting here now. There is no whisper of stating that like your original documents were not received by them, rejected by them. You have not stated in your
Malad,
representation.
in my early representation, Lordship has
Earlier
seen.
representation, so you haven't stated so.
Yes, Malad. That is the Malad. This is
So, see,
subsequent
I mean,
to earlier,
submit-
earlier incident.
what
Malad.
you are submitting before this court right now is different than what you have represented before the superintendent.
Malad, facts remain that all the Malad the time during this entire period, Malad, the executive engineer were remained absent, Malad. For which Malad, it was not done anything, Malad. This is Malad. This
That's
facts,
a different
this
issue
fact-
that has to be considered.
Malad,
That's a
these facts
different
may be
that has to
kindly
considered,
considered.
But facts, as we can see from these representations and by
Lordship may
reading
kindly appreciate
together
one.
with this letter,
Lordship may kindly appreciate one thing. Malad, during entire this period, the executive engineer remained absent, Malad. Even if Malad, my original documents is processed, Malad, any other things is Malad processed. Malad, admittedly, I have no case, Malad. Malad, without Malad accepting my original documents, even including EMD, other documents, that was not processed. But the Malad, now they are saying that no, your bid has been rejected on so and so ground, Malad.
where is the rejection?
Rejection is Malad in their affidavit. Malad Lordship will find at page number 146, Malad. The ground of rejection is also, my lord, different. And it
Let's
is
see that, let's see that. That's what. That's
to,
what we want
to
to
so and so,
see.
my lord. It is on 3rd July, my lord.
Phase one,
Even before the, my lord, last date of submission,
Phase one?
146, my lord.
46.
This much before the expiry date of the Malad. That has been extended, still then that has not been taken into consideration. Even last date is also not Malad expired. 3rd July 2000, Malad addressed to me, non-fulfillment of the section 3, condition of contract under additional special conditions at the time of processing P regarding Malad. With reference to the above, reference to your participations in the bidding process for the work, the upgradation and so, it is hereby informed that at the time of the examination of oblique collections of the processing fee, it was observed that the requirements stipulated under section 3 conditions of the contract under additional special conditions were not fulfilled. Manner. The bidder, the failings to fulfill the above the conditions of the approved the uploaded NIT may be treated as non-responsive.
Okay, please tell us what is this?
Now, my lord, my submission is
No, not your submission. Requirements stipulated under section 3. Where is that? Section 3. Show us.
section 3, my lord. Therefore, my lord, on the last occasion, my lord, original documents was called for, where that
No, we'll come to that later on. Tell us what is section 3 of conditions.
page number
of contract.
136, my lord.
Hmm?
Page number 136, my lord.
136.
Yes, ma'am.
What is that?
136, my lord.
Clause 26.
Close 26, my lord. Page number, my lord, this may be my lord, internal page 68. I don't know, my lord.
Section
even
3. Why do they say section 3?
Section 3 not mentioned, my lord. Even it is not. Therefore, my lord, on the last occasion, my lord, this records was called for, my lord. Section 3,
The requirements
not mentioned.
stipulated under section 3.
Section 3 is also not, my lord, maybe bulky, due to bulky documents, my lord, that has not been enclosed, my lord. Only this clause, extract copy. This is the extract copy of page number 68.
What is section C? He disclosed this.
Not,
That is the ground for rejection. Section 3 conditions of contract were not fulfilled. So what is section 3?
not only section 3, my lord. Section 3, condition of contract under additional special conditions not fulfilled, my lord.
So under section 3, the heading is that conditions of contract, correct?
Right.
Section 3 is conditions of contract.
My lord,
And under that section 3, under additional special conditions were not fulfilled. So you'll have to show us that section 3 first, that conditions of contracts. Under that, there is an additional special conditions.
correct.
So that has to be shown to this court.
My lord, I'm fairly admitting, my lord, that positions that I have no documents on that, my lord. Therefore, the record was
Yes,
called
the
for.
government
Yes.
council, do you have it? The record? Yeah.
It's a password, my lord, NIT, my lord. You'll also find, my lord.
Page number?
It's a
471.
471.
471? 471.
There is no 471.
No,
In,
it's a two
other
part, my lord, two parts.
yes, additional special condition.
Yes.
My lord,
For
our case is at page 473.
473.
26 were not fulfilled.
Okay. So that's why clause 26 has been extracted here.
Yes.
Processing fee shall be collected, okay.
Processing fee shall be collected from the division of office from the assigned person and duly countersigned by the assistant engineer by the bidder representative on production of bidders. Original identity proof, fees, PAN card, Aadhaar card, concept registration certificate, that is his farm registration certificate. Also, the sir, failing which no processing fee shall be received or processing fee received not in order shall be summarily billed.
Yes.
The original document were required to be manual furnished.
H.
You have not.
Before that,
You have not annexed the document properly.
my lord,
Yes.
before that,
Yes.
may I show your lordships to the page number 11, my lord, page number 66, my lord.
Yes.
My lord, page number 66, additional special condition. It starts from serial number 1, clause number 1, clause number 2, clause number 3, up to clause number, my lord, it is up to additional, my lord, up to, my lord, the clause 29, my lord. Kindly, my lord, peruse page number 471 H. My lord, additional special condition.
You said 66, now again 471.
My lord, internal phase.
There you say that.
Internal phase, my lord, they mark 6, my lord.
When you
But,
say
my
two
lord,
page numbers,
is
there is
designation
that.
is, designation is 471. My lord, additional document, additional special condition.
Yes.
Clause contains from 1 to serial number 1, 2, 3, 4, 5 in page number 147. It contains up to clause 7.
26 is the relevant one.
Yes.
26 is not at all there, Malan.
26 is not there. So this is page 473.
473,
473,
internal page 68.
Malan, clause is just Malan, may I clarify? Clause number 1, 2, 3 up to 7. And next page is 8 to 23. And next page is 24 to 29, Malan.
Correct.
And there is no, Malan, the special condition, Malan.
No, this is special condition only. You see the heading first.
Heading first, Malan. And from
Additional special conditions, page 471.
471, there is no mention, Malan.
You see the top H?
This is additional special clause conditions.
Malan, condition, just for a moment, Malan, may I again, just to clarify.
See, section 3 is conditions of contract.
Correct, Malan.
Under the conditions of contract, there are several subheadings.
Subheadings.
One of the subheading is that number H, it is marked as H, additional special conditions. And that has been mentioned by them, additional special conditions.
Additional condition, Malan, there is no, Malan, Lordship will not find clause 26, Malan.
This is 26, page 473.
473, Malan. Yes, Malan.
Serial number 26 is there.
Okay, what
What you are saying? Mr. Nabam,
Yes, ma'am.
one thing, you'll have to clarify one thing to this court. I mean, this letter dated 3/7/2025.
my lord?
Why it was issued on 3/7/2025, whereas your this thing was open till 5/5?
My lord, that was my lord intimation, my lord.
Not intimation, rejection, Malan.
Yeah, rejection,
Rejection,
my lord.
rejection.
Yes, rejection.
Why?
Informing my lord, you have not complied with my lord.
Why
section.
before closing it? Yeah, closer date was
14, Malan.
No.
fifth, at least 5/7/2025. See, bills can be deposited before specified so and so within document in cash, EMD and other original documents from 36/2025 to 5/7/2025. Then
Well-
why you have issued this letter on 3/7/2025? Whereas they have gone to your office on 3rd and 4th.
Fault, my lord. That is the claim, my lord.
No, that has been admitted also, because admitted by your officials.
My
Your
lord-
officials has written that documents have been received.
Yes, receive on not fourth but on third, my lord.
Hmm?
On third, my lord.
When?
Third.
No, they have said that they have received it, correct?
Yes, ma. They have received it, my lord. He said, my lord, on 2 occasions, man, he visited the office.
No, I mean, before scrutiny of this document, before completion of the scheduled date,
My lord.
how can you reject this document? I mean, their document, their bid, before the scheduled date of.
My lord, not bid document we have rejected, my lord. My lord, rejection will come once, my lord, his tender document is processed. Complied with section 26, my lord.
Correct,
Now,
very
my lord.
correct.
Right, my lord. Now, what my friend is saying, the petitioner, that they tried to submit the original document and we debarred him, my lord, by not accepting.
No, just leave apart his submission.
Then-
You consider this code,
yes,
why
the
this
push-
was issued on 3rd.
Yes, my lord. Lordship may kindly note, the last date, my lord, for submitting these original documents is 5th. And it was extended because of representation submitted by them, 4th and 14th, especially 4th, my lord, that we need some more time. So till 10th, it was extended, from 5 to till 10 extended. We have intimated him that we are cancelling on this ground that you have not submitted, so that he could submit a fresh, my lord, document. My lord. Yes, ma. Time is there, ma.
You should have requested him that you submit it, but you're cancelling it.
No,
What
no.
you- I mean, what you're saying then?
Rejected, Malan.
Not accepted, my lord. Not exactly rejected.
With
Accepted.
reference to your participation in the bidding process for the work so and so,
No,
it is hereby
It is not
informed that at the time of submission stroke collection of the processing fee, it was observed that the requirements stipulated in so were not fulfilled, correct?
Yes, correct,
Wait,
my lord.
wait for a minute. Bidder failing to fulfill above condition of approved uploaded NIT may be treated as non-responsive.
Non-responsive, my lord. Non-responsive, my lord. Huh? Ito. My lord, definite, huh?
So you may be correct.
My lord,
So
now,
you may be correct.
My lord,
It is not a cancellation.
yeah, it's not okay. My lord, we receive his document, whatever application, my lord, on TAT. What my friend is saying, my lord, on TAT and TAR, they educated
Mr.
engineer.
Kato, you should be a little bit careful about your submissions. I mean, see, that this court, it may happen because of a lot of bulky documents. This court may not read each and every sentence. So while you're making submission, you should make a correct submission. You should not say that this is, you say that this is a cancellation. So this court presumed that this is a cancellation without reading the whole document. So while doing it, so you should be careful. So you should be careful and you should assess the court properly. So you should not, I mean, somehow suddenly submit that this is a cancellation. This
Malad-
is not a cancellation letter.
My lord, my precious submission is, even this document has not been received by me.
But that's a different thing,
Malad-
Mr. Kato.
Ma-
That's a different thing.
My lord,
But while making a submission, you use the proper word.
my lord, my submission is, my lord, by these documents, it is not, my lord, it is amounting to cancellation in tender documents, my lord. Of course, this
No.
terminology is used, not responsive.
Already intimated that your tender may not be considered because you haven't paid the process fee. This is what this letter transfers.
Exactly, my lord. That's why I'm asking myself, without, my lord, processing how they have accessed and how this rejection has been done, my lord. My lord, precisely, my lord,
It was your rejection, rejection,
Malad-
not this letter.
in the, my lord,
See, when we asked you, we asked for the rejection document, whereby your tender was rejected. But you have shown us this document.
Malad-
So we also presume that this is a rejection document. You show us the rejection document if there is a rejection document.
my lord, had there been, my lord, issued the rejection order, my lord, I could have annexed, my lord. So till now, my lord, that has no, in tender process, lordship aware, my lord, that the terminology used by them is the non-responsive, my lord. Other than these documents, nowhere, my lord, any documents has been correspond to me, my lord. So whether it is rejection,
So
whether
after
it
this
is
document-
non-responsive,
So
whether it is cancellation of my
after this
documents,
After this document, no document was issued.
my lord.
One thing, tell us one thing, whether this observation that it's non-responsive
My lord.
debars you from rectifying
Correct.
whatever shortcomings were there and to resubmit.
My lord, kindly appreciate one thing.
Does it debar you?
My lord, may
If they
kindly,
say that it's non-responsive, then you may find, okay, which part is non-responsive?
my lord,
Tell me, I'll rectify. I have a date,
yes,
5th is the last date.
my lord, may I-
You can go back and get it.
my lord,
It was extended to 10, my lord.
By 5th, you could have done it, if not by the extended date.
I'm highly obliged, my lord. That had that been, my lord, much communicated to me earlier, my lord. My lord, admittedly, that rectification is, as I have pointed out, as per the CPW manual, my lord, there is a, my lord, the one provisions for, my lord, the rectification of my deficiencies, my lord. But, my lord, the irony is, by way of, my lord, affidavit, filed by the respondent number, my lord, 4,
No,
This
Mr. Kato, you,
by this,
Madam,
that time,
my
my
lord,
lord, time has already been expired.
Mr.
my lord.
Kato, my lord has asked you a very specific question, very relevant
madam.
question.
I'm
So answer that. See,
Ans-
you have been issued this letter
correct, madam.
saying that your tender may be cancelled because of non-responsive.
True, madam.
And the tender date was extended as per
True, madam.
Mr. Nabam.
My lord, I got,
Then
madam.
what, after receiving of this letter,
Madam.
what rectification you have
My
done?
lord, I got, my lord. My lord, this has been come to know after filing of this affidavit by the respondent number 4 on, my lord, 5th August 2025, my lord. By which date, my lord, that has expired.
So this letter was not received by you.
Correct, my lord. That is my contention in the
That is what
affidavit
you-
in the reply
That is
also.
what you should say beforehand, that though this was issued, I have not received it. You haven't said it so.
No, my lord,
Only in one
my
sentence.
submission is not yet completed, my lord. I'll
Only in one sentence you could have said that,
Yes.
that because I did not receive this letter, that's why I did not know that
my lord, in the
there was
beginning,
some
my lord,
problem.
in the beginning, my lord, I've made that
Mhm.
submission, contentions of the other parties, my lord, saying that your bid has been treated as non-responsive, because of which, my lord, that condition, that point, my lord, in the beginning, I've made, my lord. Their contention is, you have not fulfilled this condition, because of which the rejection, and that documents is even have not received by me, my lord. Even in my affidavit in the reply, when this affidavit in opposition has been filed by the respondent number 4, my lord, I made my categorical statement in the affidavit in the reply that no, I have not received any
Okay,
document.
show us this, show us this, show us this.
Page 146 is from the counter affidavit.
Yes, ma'am. It was, my lord,
Okay.
page
What is the annexure?
annexure 110, my lord.
Huh?
Page number 110 of the writ affidavit, my lord.
Annexure number.
Affidavit filed
How-
by the respondent number 4.
How is this 146 annexed?
146, my lord.
Is identified as what annexure?
146 is the, my lord, as I pointed out, my lord, this is the rejection non.
Oh,
This-
page number,
Lecture, what?
page number we know. You tell us which annexure is this?
Lecture. Lecture 1, 2, 3, consider.
This annexure, my lord.
This is a government affidavit, right?
Yes, my lord. Respondent number 4.
So you haven't marked annexes.
Annexure 2, my lord.
Yes, ma'am.
It's not marked?
Annexure page number 106, my lord.
The whole affidavit.
This has been put as annexes.
So therefore, my lord, we only came to know by filing this affidavit that by that time, my lord, it was already expired. Notice were issued by this honorable court on, my lord, 24/11/2025, my lord.
So your contention is that this letter was not received by you and you got to know about this letter only through the affidavit when they filed the affidavit, right?
Yes, my lord.
And you have stated so in your pleading in reply.
Correct.
So where is that
That
reply?
is there, man.
Huh?
Yes.
I continue. That is,
It is there.
it gets worse actually.
Your reply is at which page?
We can go to interpretation.
Start from 571, man.
5/7.
Marking tabela.
That's much there, but there was one before that.
Let's see how it is.
Paragraph, which paragraph it is?
It was not pointed out by the petitioner, I pointed it out.
This happened to be even in the read proceedings, my lord. Page number 576, my lord.
Paragraph 7.
7.
Para 7.
Yes, ma'am.
Page 57?
576.
576. And another is at also, my lord, page number 601, my lord.
Petition was never issued any written petition.
Which paragraph is this?
Para 7, my lord, of page number 576. Para 7, my lord. Para, my lord, it starts from petitioner was never issued any written deficiency notice or given a fair opportunity to resubmit the documents, while two paper firm were processed and accepted. The subordinate officer of written statement so and so, my lord, that has been already the lordship has seen. And another, my lord, the refuting paragraph is at page number, my lord, the 601, my lord. In fact, this issue was raised by the different, my lord, respondents. So therefore, my lord, page number, my lord, 610, para 8, my lord.
601.
601.
Don't keep on changing the page number.
There is no 601.
No, he says 610, it's 601.
601, my lord. I'm sorry, 6.
Paragraph 8.
Page number, para 8, my lord.
So same contention here.
Self contention, madam. And by that time, madam, when the affidavit was filed, madam, it was already expired. So therefore, madam, in the tender process, madam, fair opportunity has to be given so as to, madam, they participate, allowed to participate the intended tenderer. This is the, madam, the principle and the ratio of the, madam, the decisions of the, madam, the Katana decision of the Honorable Supreme Court. So therefore, madam, once it, madam, the fair opportunity is given to all intended tenderer, madam, no harm will be caused to the, madam.
So was the, I mean, where this thing was discussed by the learned single judge?
Page number, madam, impugn judgment is page number 609, madam, annexure 6.
Start from 620, madam.
And relevant paragraph is impugn judgment, page number, lordship will find at page number 609, madam.
Relevant portion.
Relevant, madam,
619, madam. There are 21 numbers. Kind. Clarify everything.
Paragraph 19, sir, okay. 17 is to discuss from 17. About additional special condition.
This is about what? Production of original identity proof. PAN card, Aadhaar card,
Yeah.
contract registration.
I can show 3 documents, the case will be clear. This is all that is required.
no, madam, another contention is, it is a perm, madam, the PAN card cannot be issued in the individual name, madam.
Not needed case.
And madam, another, madam, that while rejecting, madam, that has to be specific, madam. In your impugn rejection order, madam, the purported rejection order, you have not mentioned anything, madam. Entire things, madam, this has not been fulfilled, this has not been, madam, complied with.
Have you,
Clause 26 says that.
Madam,
Clause 26 says that.
madam, 26 says then, madam, if, madam, that specific has to be given, madam, in some, all documents are not required to be produced from the perm, madam.
What about the proprietorship? Owner can prove it.
You were saying the PAN card or what? Aadhaar card is not issued to the farm.
Madam, in such proprietary firm, PAN card cannot be issued individually, madam.
Why not?
What about the other firms then?
Other
What do
card,
they produce then?
madam, proprietor of the individual,
see, I mean, in all contracts, what happens is that there is the companies usually or firms, they authorize a person to do the contract. And usually in big contracts, you are supposed to give the name also
correct,
to the employer. Correct. Employee means the authority.
correct, madam.
Now, once the assigned person is known to the authority, then they can accept it with the identification, showing that like you are the authorized person. So only thing is that you need to show that I am the authorized person on behalf of the company, and this is my identity proof. And this is what basically they have asked for, nothing else.
Madam, if we again peruse the, madam, the language of the, madam, the clause 26 is something different, madam. It is not about, madam, individual who produce, madam.
No. It is like that. You read it. Please read 26.
Processing fee shall be collected from the individual, divisional,
Division office PWD Yamcha. Correct. From the assigned person
correct, madam.
and duly countersigned by the assistant engineer Yamcha PWD subdivision
Madam,
by the bidder
madam,
stroke authorized representative.
madam,
Authorized representative of whom? The bidder. On production of bidder's original identity proof. For example, wait. For example, they are saying these. They are saying PAN card, Aadhaar card, contract registration certificate on so and so. Failing which no processing fee shall be received, or processing fee received not in order shall be summarily rejected.
my lord, bidders in this instant case is the my lord MS Badri Rai
So
company.
you have authorized the person, no? So he,
My lord,
that
they are
he-
not ask-
he needs to carry the authorization as well as the identity proof.
On
That's all.
my lord, bidders, my lord, representative of the bidders is one thing, and the participating person, but my lord, who
So
participating in
they
the
have
tender is
given, they have given a stroke there. Bidder stroke authorized representative.
my lord. On
So it's very simple. You just need to, you also authorize somebody, isn't it? You authorize somebody to do certain works for you. So like, what do you do then? You authorize him and give you, and like he carries his identity proof saying that, okay, I am so and so, I have been authorized by this person. That's all.
my lord, it is just my lord, may just my lord, may
Yes,
make
yes, please,
submission.
please, please.
On production of bidders identity card, identity proof,
Hmm.
not the my lord, authorized representative, my lord, if I am not my lord, correctly interpreting the word. It is all about my lord, the bidders, my lord, the proof,
Bidder's original identity proof.
not the representative. Representative is in one aspect, my lord. Admittedly, my lord, lordship has pointed out. But my lord, in the next line is, it is only on the production of the
Okay,
bidders.
bidder's original
Yes,
identity
madam.
proof. So bidder's identity proof is PAN card, Aadhaar card, contract registration.
These documents, some documents are not required to,
Contract registration certificate?
that I produced, my lord. That I have produced. Even I have enclosed in my read petition also, my lord.
Aadhaar card.
Aadhaar card, my lord, some documents cannot be, my lord, issued in the name of, my lord, such contractor firm, my lord. Partner firms, man. In firms, man, so many documents are not required to be produced, man. Therefore, the registration, authorized representative can be produced, man. If I am authorized, I can produce my entire detail, my lord, identity. But if, my lord, some in the firms, some of the documents are not required to be produced, man. Therefore, my lord, registration is there. While registering as a contractor, whatever the class may be, my lord, required documents are being submitted, my lord.
Kindly get 148 by the way. That's what that means.
148. See, PAN card is issued to companies. PAN card is issued to, I mean, if you are, I mean, definitely it's issued to.
Registered by.
My lord, just a minute, my lord.
148.
Your lordship may kindly say, my lord, they are my lord company. So
So they'll be
but-
having their old.
Yes, company must be owned by somebody else, my lord. There are three names. Individual names are there. Obviously, they'll have a PAN card. Obviously, they'll have an Aadhaar card. Malay is a business transaction, all connected with the bank. Unless you don't have this document, even the, my lord, the bank will not, what you call, make any transaction, my lord. Even for opening of an account also, my lord. These documents are mandatory, my lord.
148 is a copy of the register, the original should be here. 149 is the that copy of the serial number 3.
Yes, Kali Yamcha,
Yes.
Kale Yamcha,
authorized
yes.
contractor.
Registration, PAN card, Aadhaar card not submitted.
Not submitted.
Documents mentioned above have not been produced.
Produced.
Contractor registration, input contractor registration certificate. That was the reason he was intimated. So rectified it. And it was forwarded, remarks your lordship will see, forwarded to E for further purpose, please. Now he says, he did not even receive the intimation. Then what prevented him, my lord? The registrar says, he did not submit the original document. In terms of the, my lord, there's a pre-bid meeting, everything was, everybody was told. So what prevented him from thereafter furnishing? This is the simple case, my lord. He did not furnish it. He did not have it actually, the END. That's right.
What is this 149?
The farm is based at Tinsukia, my lord.
No, page 149. What is this?
149.
Type copy of what?
Maintained while receiving the documents.
Okay.
Applications, my lord, for
While
For
receiving
processing,
the documents, they're maintaining this register.
yes, my lord. So every division, they maintain a register, my lord. What sort of document they have received, my lord?
So this was on 3/7/2025.
That is
Yes,
what he was intimated by.
So the signature is there.
Yeah,
They have received it.
Yes.
received it.
They have received it and they have been intimated.
Yes.
My lord, my respectful submission, as I have pointed out, my lord, I have not received these documents, my lord.
But who
How,
signed this?
my lord,
Then
we
who
don't
signed
know,
this?
my lord.
I?
Whoever, my lord, we don't know, my lord. Therefore, my lord,
Authorized person,
You mean, my lord, he has not received it?
Kali Yamcha received it.
Yeah, was there any meeting, pre-bid meeting? A pre-bid meeting, is there in, I mean, minutes of the meeting?
no, my lord. They have not produced. That is not enclosed even in the, my lord. Their reply also.
In any case, but
Mr. Nabam, do you have it? I mean, any pre-bid meeting?
Pre-bid meeting, my lord, I don't have. Last time, the Honorable Court especially directed, my lord, to produce this original record of this register, my lord. This, your lordship just seen, page. number-
This register.
Yes, original, my lord. What
Original.
sort of document they have, my lord, produced or submitted, my lord, before the division, my lord. We have the documents, my lord. It's all Xerox copy, my lord. We have received that, and according it was, my lord, forwarded to the executive engineer for further course of action, my lord. Well, scrutiny, it was found, my lord, it is not conformity with the clause 26. So it was intimated, my lord.
So they have been asked, I mean, since you have not submitted the bid document with proper documents, so
Yes.
you rectify it. I mean, saying that it may be cancelled.
My
It
lord.
means that.
Yes.
So, but they haven't done that.
Yes, my lord. It was extended, my lord. It was up to 5. It was extended to 10, my lord.
No.
Because, no. Corrigendum is there. Come on. It's a part of record, my lord. We have, it's a part of the record,
Yeah,
my lord.
corrigendum
Corrigendum.
is there, Mr.
Yes, my lord.
My lord.
Corrigendum?
Yes.
Yes, corrigendum.
My lord,
Yes,
It is
extended.
very easy to make submission as because that to that extent, my lord, they are not even proof of any documents that yes, this has been extended. Please kindly do this.
No, where is the corrigendum? I've seen it. Yeah.
Corrigendum.
petition matter, how to say.
I think I have seen this.
97, my lord.
I have seen this.
My lord, that has not been. My lord, it is my pleaded case. My lord, it is my pleaded
I'm
case.
sorry, my lord. Page 97, my lord.
It is my
Yeah.
pleaded case that has not been taken into consideration, my lord. No, my lord, that has not been taken into consideration.
No, you have stated that,
Corrigendum, my lord, of
it
course,
was not extended.
my lord, corrigendum was of course issued, but that has not been taken into consideration, my lord.
96 type of is, my lord, 97, my lord. Now, can you produce any document that within this period you try to
My
submit?
lord, this is the
original document?
technicalities. They are
No,
taking the
it's not
advantage.
technically. No, this is not technical.
Now they are, my lord, making the issue on that aspect, my lord. There is no, my lord. My lord, is there any correspondence that yes, this has been taken into consideration that please submit, resubmit, or other
No,
intimation?
no. What is the answer to this register?
Register.
Register, my lord, of course, my lord, as I pointed out, my lord, my submission, my lord, we have not received, my
Serial number 4.
lord. Serial number 4, my lord, of page number 140, my lord.
My lord, 4 bidders, my lord. 2 bidders were rejected because of non-submission of original documents, my lord. Him and one more, my lord. That, yes, the farm number 2. Yeah, of course, was, my lord. 2 farms were rejected, my lord. May I just point out one more document? My lord, my friend is saying, my lord, he has no knowledge about that. His documents was not accepted, my lord. My lord, on 3rd, my lord, we have intimated him by letters, my lord. Same that we have WhatsApp him also, my lord. You also may kindly come to page 47. He has seen the WhatsApp, my lord.
Page 47.
147, yes, my lord. Very next
147.
page, my lord. Very next page.
Okay, this one, yes.
Yes, my lord. This is 16.19 hours, my lord. That means, my lord,
A scan copy of the
Yes,
the
that
data,
WhatsApp.
data was sent.
yes, my lord. Down below, your lordship see, my 2 tick marks. That means, my lord, he has seen the WhatsApp, my lord. Your lordship may kindly see 2 tick marks, my lord. How can you say? It's almost like a, my lord, ulta chor kotwal ko date, like that, my lord.
Originals could not be submitted because the executive engineer was absent. That is his only.
Correct.
The record shows otherwise.
Then-
He not submitted the original documents.
One more thing, your lordship seen the EMD, my lord, the maturity data 2, my lord. And he has submitted the tender document on 3rd, my lord, the application, my lord. That is the reason, my lord, he could not submit the original. That's simple, my lord.
My lord, regarding this 147, my lord, how this has been done, my lord, that is another aspect, my lord. The documents, my lord, the real documents has to be, my lord, original document has to be, my lord, given. My lord, how we can verify this WhatsApp copy, my lord? This is not, my lord, at all related thing to, my lord, tender process, my lord.
No. WhatsApp copy, which has been given, the scan copy of the notice was, the letter was sent to you.
Same letter.
In
So
such
that a proper opportunity and fair opportunity is given to you. And you have got to know about this.
my lord,
You have got to know about this because you have received that WhatsApp notice.
watch out, watch out.
And corrigendum was issued extending the date. That also you were aware.
My lord, in such a
Then in
situation,
spite of that, you didn't submit the documents.
my lord, in such a situation, my lord, how can we, my lord, verify the, my lord, the authenticity of the, my lord, some documents which has been sent unofficially, my lord.
Unofficially means?
Unofficially, my lord, even if, my lord, considers to be this page number 47 to be correct, my lord, still then, my lord, documents has to be, my lord, such opportunity has to be given, my lord.
Opportunity has been given to you.
Only this is the, my lord, the purported intimation and basing on the some other documents.
Yes, like, I mean, anything more?
My lord, yes, my lord, my submission is, my lord,
So you have submitted already. I mean, your whole case we have understood.
yes, my lord, that is the sum and substance, my lord. But what I am submitting is, my lord, the fair opportunity has to be given. So that, my lord, at the very instance, my lord, so, my lord, that opportunity can be, my lord, availed.
The
Right.
fair opportunity should be given. That is kind of an universal truth. But fair opportunity to be given to someone who complies with the conditions.
My lord, this condition has been, my lord, as I, my lord,
Anything
my-
else you need to, Mr. Panging and
He did not present, so he could not furnish the original document. That is his case. Nothing else. That is his only case. Records reveals he did not submit the original document. In fact, the submissions are incorrect. In fact, the amount basically in the court. He did not submit the original document. Only the photocopy was document. He left this in violation 26. He was intimated. He further did not do anything. There is a simple case.
My lord, number one, my lord, right from the beginning, before the landed single court, my lord, he is very aware, my lord, that there are two successful bidders, my lord. They are necessary parties. That was not met. Even before the appellate authority. If the lordship passes any order, they will be the agreed person, my lord.
yes, yes.
The number one. Then number two, my lord, what he is saying, my lord, my brother said, my lord, it is not the duty of the executive engineer to receive this application, my lord. The authorized person has been given to two junior engineers, my lord. So his remain absent, my lord, it cannot be said, my lord, that his tender document was never received, my lord. It was received, it was processed, and it was not accepted.
From your side.
yes, my lord.
Yes, my lord.
My lord,
So that way, my lord, his submission is
My lord,
just a minute, I will finish. Let me.
Yes.
Then, my lord, now, as per my lord, section 3, the additional condition, 26 very clear. If the lordship see the NIT also, clause 5, 8, and 9, clearly says, if you fail to submit this document, your proposal will be summarily rejected, my lord. It is a part of the tender condition, my lord, which he never challenged. Now he says, my lord, now very openly that it has been tailored in such a fashion to, my lord,
Favor those people.
favor to private respondent, my lord. Then why you have not challenged? You never challenged, my lord.
no, my lord, as
So
of,
of late, my lord, you can't say, my lord, because now what we can say is just nothing but it's hard burning. If I don't get, you also don't get. Go for fresh tender. My lord, these are the only, my lord, working seasons going on. It's a, my lord, expansion of, my lord, road, my lord. Now road connectivity, your lordship is very much aware, my lord, how public importance is there, my lord.
no, my
That's
lord,
my submission.
no.
When this is also, this case is the executive engineer or something. The lordship is close to this. It is the countersign of the state engineer that is required, not the executive. The state engineer there.
That's all, man.
In fact, it was the E. EE.
E,
No,
Assistant engineer.
executive engineer.
assistant engineer, not E, my lord. Executive, not executive engineer. Assistant engineer, my lord.
See.
Yes.
I mean, receipt of the countersign needs to be taken from assistant
So
engineer.
as per the clause.
And
As per
approval
the
will be
clause.
done by the executive engineer, my
Now,
lord.
my lord, as for the NIT, my lord, executive engineer has to, my lord, the issue accept, my lord. My lord, lordship has seen the impugn NIT, my lord.
Except,
What is the role of the assistant engineer?
my lord, he'll put the initial signature. After his signature, it will go to the executive engineer for final approval, for final scrutiny, my lord. So on third, my lord, executive, junior engineers, my lord, were present.
That is not the ground of
Assistant-
rejection, my lord.
Assistant engineer were present. That's why, my lord, on third, my lord, his application was forwarded to the executive engineer, my lord. And third itself, my lord, it was found, my lord, is not complied with the clause 20 section, clause 26. And third itself, my lord, it was intimated to him, my lord. It's a latest on his part, my
My
lord.
lord, may I take your lordships to clause 5, my lord, again, my lord. That means thereby, my lord, it is a contrary to the clause 6, my lord. Clause 26, my lord.
No.
Now, my lord, what has to be done is first, my lord, lordship, may kindly peruse page number 58 again, my lord. NIT, my lord.
Yes,
My lord, by my lord, this press notice, you are specifically mentioning the terms and conditions, what has to be done, my lord. The bidders can be deposited before the specified date by paying the cost of the bidding documents non-refundable in case so and so, along with the EMD and other original documents.
Original
to the
document.
Executive engineer, my lord.
But 2D is an address, my lord. 2D is that
No,
not executive
this-
engineer
this-
to receive? Come on, read like this. Address has to make to the executive engineer.
Deposited, my lord, not the two. address.
Obviously, entire tender document has to be addressed to the executive engineer.
Why another terms and condition you are mentioning the 20 in clause 26 that this has to be done by that way, this way. My lord, this terms and condition is clear. This has to be deposited with the executive engineer, not the assistant, my lord.
Just for like that. Well, tomorrow's, my lord, recently, my lord, we have issued the NIT for the canting, my lord. Is it necessary that registrar has to accept, my lord?
My lord, then in
Obviously, it will be in the name of my lord, registrar, my lord.
that is the my lord, the flaws.
Come on.
That is the my lord,
This is
deficiency.
which paragraph you are relying on?
Yes, madam.
Paragraph 5, my
So
lord.
therefore, my lord, in my
Paragraph 5.
Paragraph
no, my
of the
lord,
NIT.
no, my lord. I am
Then,
No, that
Page-
is this case.
para 16, my lord.
Para 16.
Yes, ma'am. Of course, there are so many judgments, my lord, right from my lord, Tata Cellular to till my lord,
I don't know what ratio.
my lord. Now this is my lord, from the latest, just lordship, I'm relying upon page number 16. Oh, sorry, para 16, my lord.
Public trust and all.
Yes, my lord. Para 16, my lord, fair opportunity.
Yes, we'll consider.
And another, my lord, judgment.
I written the on behalf of his respondent and the paragraphs also.
Okay.
My lord, it is reportable, my lord. I've already placed
This is from
from my lord. Shakti Construction Private Limited, my lord. First one, my lord. Lordship has already seen that
Paragraph.
my lord, in
This Madhya Pradesh case, paragraph.
Madhya Pradesh case, my lord, it is paragraph 54, 58, 59, 60, and 61, my lord.
54,
54, 58,
58,
59,
59.
60, 61, my lord. In earlier one, only one paragraph, my lord, para 16, my lord. In the case of my lord,
Correct.
Shakti Construction.
61,
Yes, my lord. 16, my lord.
16, 16.
16.
16, my lord. In earlier case, my lord, in Shakti Construction, my lord, I'm relying upon my lord, the para 16 only. And in second, my lord, the pragmatic infrastructure, my lord,
54, 58,
yes, my lord, Madhya Pradesh housing, my lord, in
59, 60, and 61.
correct, my lord. Of course, my lord, there are so many other judgments where, my lord, this is the latest one. Therefore, my lord, I'm relying upon this. My lord, in that such standard process, my lord, it is the my lord, the core principle of the my lord, in such standard, my lord, the process. Equal opportunity, fair opportunity has to be given, my lord.
Yes.
Mr. Pangani, you are appearing for?
I have the executive engineer made party by name.
by name, my lord.
By name.
By name.
My lord, the last occasion record was also called for whether the record.
So only for the register.
Yes, my lord. So I have, my lord. Yes.
We'll just have a look. Just give it to me. I'll just have a look. Then if required, then we'll keep. Otherwise, we'll retire it. Just. Maybe the register. Yes.
Serial number 3, my lord. Serial
Yep,
number-
the flagged one, no?
Yes, my lord.
Yes.
Remark, my lord, extreme right, my lord. Yes. So those are the documents which they have submitted.
They have submitted.
Yes, all Xerox copies, my lord.
Xerox copies.
This is the document they submitted.
Yes, my lord.
And is only the forwarding letter.
Actually, they are mixing up the two things, my lord. Documents which I have submitted in low sheet, which is not original, and the documents which required to be submitted in original, they refuse, my lord. That is the, my lord.
New development, my lord.
No, no. From the beginning, my lord, this is the my
New
contention.
development.
And without, my lord, my original documents,
No, I'm just furnishing two sets. That is for justice side.
Yes.
Two sets I have already furnished for.
Yes, thank you.
Citation.
Yes.
my lord, may kindly appreciate one thing. My lord, that, my lord, he is, my lord.
I think the other case, I don't have it. This, you have submitted Air India, right?
Yes.
The Cochin Airport. And the other one,
Tata Motors.
Tata Motors, I don't have a copy. We'll make it. We'll write. We'll give it CV. CV, then it'll take some time because I have some more on the plate. No. We'll return it.
My lord.
We have produced it.
Any citation, my lord, I can also give, my lord, because fact is so clear, my lord. I thought,
My
my
lord.
lord, for
My lord, my,
extension may not be required.
my lord, my last submission is, my lord. My lord, my life is that this is the another contention, not my lord, not exactly, my lord. My contention is documents which they have received is not original. The documents which required to be deposited is the original, which they refused, man.
Lordship, may kindly note, my lord, the document which he has submitted is not the original. He has considered, my lord, kindly note.
That is the only, my lord, the EMD, my lord, that is still with me, my lord. Original, my lord, the original EMD, which they refused to receive, is still with me, my lord. Lordship, has they seen the, my lord, the EMD? My lord, still, my lord, the huge amount, my lord, 39,70,000 is still pending in favor of the executive engineer, my lord.
And your EMD is, EMD has expired.
Expired, my
My
lord.
lord,
My lord, you lordship, may kindly
technically,
note,
we don't know, my lord. Documents is with me, my
My
lord.
lord, entire, my
It
lord,
is still with the
representation,
bank, my lord.
4th and 14. There is no whisper that we have rejected or we have refused to accept the original document. There is no whisper about that.
It is only for 1 day.
No, my lord, it is still with them, my lord.
No, no, no.
Technically, my lord, the
No, the maturity, the date of issuance of maturity is 1 date. only.
my lord,
27.
that may be late, my lord, but clerical mistake, my lord. But that is still with me, my lord.
You keep-
It is still with the bank, my lord. In the name of the executive engineer, my lord.
That doesn't help you.
Anyway,
How is it possible? Already expired, my lord. Maturity date is 27, my lord. 27. It's already expired, my
all
lord.
right, we'll have to reserve the judgment. All right.
My lord, only thing is that, my lord, since, my lord, there is a stay order operating against us, my lord.
Ah,
Some urgency is required, my lord.
urgency is there, but we'll try to
My lord,
dispose it as soon as possible.
my lord.
Heard Mr. M. Kato, learned counsel for the appellant. Mr. N.H. Nabam,
All right, my lord.
R.H. Nabam, learned additional advocate general. And Mr. D. Pangin, learned counsel for respondent number 5. The hearing concluded, judgment reserved.
Obliged.
Deeply obliged, my lord.
We'll rise for a while, then come back and hear that criminal matter.
Criminal, my lord.
We would like to devote some time in the afternoon for the single bench. So we'll try to finish it up by 1.
Item number 5.
May I please, your lordship?
Yes.
My lord, in the paper book from page number 143 to 152 is the findings basing on which the conviction order was passed. Since your lordships don't have much time, I'm not going to read it, but I'm just going to summarize what is written here. The number one thing the court has said, the findings, is that the relation between accused and deceased was not good, so therefore there was a motive. Number two, the court says that there is an admission of offense before the PW2 and 17. PW2, if my lordship will recollect, is the brother-in-law of the deceased. PW17 was a Caesar witness. Then number three, the court has made its own finding regarding the time of the incident, which is very interesting. That is why I'd like to read this, my lord. Page 143. Because this is where all the presumption and assumption has been given about the time, because the time of the incident is not clear. May I read, my lord? C. The exact time of the incident is not known to everyone. However, as per the FIR, it was between 7:15 to 8 p.m. As per the evidences on record, the time of the incident is around 6 to 7 p.m. The accused did not leave Balukpung before 7:30 p.m. on the incident evening, as per the evidence of PW8. PW8 is the shopkeeper. The accused was present in and around the PO during the incident time, which casted more suspicious and strong evidences against the accused for non-explanation or unrealistic explanation made by the accused in his defense, which in turn complete the chain of circumstances. The evidence of PW8 and admission of accused is, to have visited the shop of PW8 is a strong evidence against the accused to complete the chain of circumstances. Therefore, the accused abscond from Balokpung, which is a strong evidence against the accused besides other incriminating evidence. Then, my lord, before coming to my own submissions, the other ground which the learned trial court has taken is that the accused came back only after he was trapped by PW5. The PW5 was in custody of the police and he was asked to call the accused on phone. Then another ground is that this is a case of intentional murder because the PW1 heard the sound of vomiting dog, which was 12 feet away from her home, and if it would have been a case of scuffle or quarreling, then that certainly would have been heard. That is why the court came to the conclusion saying that it is not a case of quarreling or scuffle, but a case of complete intention to commit the offense. That is one of the grounds. Then another ground is that the party at Atobong ended at 5 p.m. As per the accused statement record in defense, none of the PWs revealed when the party at Atobong ended, but it was ended when dark begins. There was a time gaping of this is regarding the time of the incident. That is why I'm reading page 145 G. There was a time gaping of 10 minutes between accused and deceased leaving Atobong Kolakem as per PW2. The accused came to the shop of PW5 after the deceased leave the shop, and there was a gaping of half an hour between arrival of the accused and deceased. Hence, the accused spent half an hour somewhere before arrival in the shop of PW5. The accused came to the shop of PW5 at 5 p.m. to 5:30 as per PW5 in his first examination, and 5 to 6 p.m. in his second examination. The accused stayed with PW5 for half an hour and had food with him. On the other hand, the accused came to the house of PW13. The deceased came to the house of PW13 to have food and stayed half an hour. PW13 got information of incident within half an hour from leaving her house by the deceased. It leads to shows that the deceased took around 1.5 hours before the incident was heard by PW. I think it should have been heard by PW1 from visiting the shop of PW5. If the deceased visited the shop of PW5 at 5 p.m., the incident took place within 6:30 p.m. If the deceased visited the shop of PW5 at 5:30 p.m., the incident took place within 7:30 p.m. On the other hand, the accused took half an hour to leave the shop of PW5 and reach the shop of PW8 at 7 p.m. to 7:30 p.m. Hence, the proximate time of accused and the deceased spending their own time at the house of PW5 and PW13 respectively are the same. PW3 and 4 heard, this is another ground, PW3 and 4 heard the sound of running of a person nearby place of merrymaking and got information from PW1 within 20 minutes. Reveals that the incident took place between 6:30 to 7 p.m. As per the doctor, the approximate time of the incident is 24 hours at the time of examination. PM examination was done on 19/2/2017 at 9:25 hours. The probable of accused happened to meet the deceased at PO before visiting the shop of PW8 within 6 p.m. to 7:30 is very naturally possible. In all probable and conclusive, is in all probable and conclusive. He's also saying probable and also saying conclusive, which is, in my humble submission, contradictory. Now, my lord, one of the grounds, thereafter, my lord, the other findings are that there is an abscondence of the accused person, so therefore, there was also one of the grounds, my lord. Now, my lord, my submissions on this, my lord.
So main ground is like he was present before PW8.
Yes. He was present
Before
PW8.
before the shop of
Shop
PW8.
of the shop owner
And he didn't answer in 313
regarding the blood on his hand. Yes,
He kept silent. He didn't say anything on this.
he said he had no comment. My lord, first of all, I would like to beg apology because on the last occasion I had stated PW8 was not examined under 161. That was because in the list of witnesses, his name was not there,
But he was examined.
but he was examined. It is there in the records also. Of course, in the examination before in 161, he said the time of the boy arriving at the shop was 10 to 11 p.m. That was again, my lord, not cross-examined on that point, so I will not be able to. So, number one contradiction in this case, my lord. My lord has read that court has come to the conclusion that it was maybe, sometimes he says maybe 6:30, sometimes it says 7:30. This is very crucial for the case because, my lord, the time of the incident, my lord, the time, alleged time of the incident. It is not clear from the records. Court has made its own, I would say, kichiri on that.
Time is crucial because the accused person or the appellant had gone somewhere else,
Yes,
isn't it?
yes.
Whether
That
he
is why I'm saying time is crucial, but the finding on the time made by the trial court, that is neither here nor there. At one point, he says that if the accused left at 7, then it might have been 7:30, 6:30. Then it might have been at 7:30 because the accused visited the shop of PW8 at closing time at 7:30. This is what, and then taking into account the statement made by the accused as his own witness and also under 313, taking all this into account, saying that it must most probably have been at 7:30, my lord. So I'm going to point out the contradictions here, my lord. Number one is, my lord, PW2, we have read earlier also, PW2, according to him, the time of incident after leaving Attobong was 30 minutes after the accused left. So it is not, the exact time is not given, but it is said because it was the month of February. We have to understand the local weather also here. Since it was in the month of February, Balukpong is a cold place. They say the PW2 says that I don't see the time, but when leaving it was not yet dark. It was about to be dark. So the time of the incident, he says, is 5:30 after leaving Attobong. So if it was because the PW5 has said that accused visited his shop at around 5 to 5:30, if it is so, then it would have been maybe around 5:30 p.m. the incident. Then PW3 says that the time of incident was 1 or 2 hours after leaving Attabong. If they left the party at 5 p.m., then he says the after party, I would say, in the construction site in which PW3 and other witnesses were there, some of the other witnesses were there, that started after 1 hour of leaving Attabong. So if they suppose they left at 5 o'clock, that after party started at that after party in the construction site where near which the deceased was found. Your Lordship will recollect. There was a party first in the afternoon. Thereafter, that place is called Attabong or Attapong. I don't know. In some places it's mentioned. Yes. After that, they went to another party, after party in a construction site, which is about 20 to 25 feet from the place where the deceased was found, near the house of PW1. According to PW3, that after party started 1 hour after they left Attabong. So that means it would have been around maybe 6 p.m. Then thereafter, after 20 to 25 minutes, that incident happened. So maybe 6:25, 6:30. So according to him, he says the time of the incident is 1 or 2 hours after leaving Attabong. So that means 6:30, 6:32, maybe 7. It could have been. Then PW13, the sister of the deceased, at whose house the deceased was said to have come and left after half an hour. If the deceased came maybe around 5 p.m., then he left after half an hour, maybe 5:30. Then she says that after about half an hour, she heard about the incident. So that could have been maybe 6 p.m. So that puts the the time of incident according to PW13 6 p.m. According to PW3 6:30 to 7. According to PW2 5:30. Then PW5, the shop owner, not the second shop owner, the first PW5 one Ajit, who was the friend of the accused person, partner of the shop, in whose shop he came. He says deceased came to his shop first and then left. Thereafter, half an hour later, accused came and then had dinner and left after half an hour. Then he says in his examination that accused must have come around 5 p.m. to 5:30 maybe, then left after half an hour.
So 6, maybe 6 or 5:30.
5:30. Accused says 5:40. He says 5 to 6. So it could be anywhere between that. Then PW4, he says that PW4 also says the party started after 1 hour of leaving Attabong. So that could be 5 to 5:10 p.m. Then time of incident, according to him, would be 6:30, because after 1 hour after the party started, then he heard some news, some sound after 20-25 minutes. Thereafter only they heard about the incident. So therefore, it nowhere sits that the incident would have occurred around 7:30 as recorded by the learned trial lord. I'm saying this, Lordship, because there are various statements according to the accused in his when he was appearing as his own defense witness. He says that I left the shop of the PW5 at 5:40. Then there was a court question asking how long does it take for you to go to the shop of PW8. He says around 25 minutes. If it's around 25 minutes, then it would be just before 6 or the 6:05 p.m. like that. Thereafter, he says that he left Balokpung from there. But the PW8 He says the time of the shop closing was around 7:30, and when we see his statement, it does not rule out that there might have been some other person also who could have visited his shop. It is not just that. Just because the accused person says that he visited the shop, just because he had admitted in his 313 that he visited the shop of the PW8, it does not automatically mean that he was the person who visited the shop last at 7:30 p.m. Because nowhere in the evidence it is said that he was there in Atobong after 6 p.m. If we take his own statement also, when he appeared as a witness, there also, if we calculate the time, it doesn't add up. It doesn't come to 7:30 p.m. Just because the visiting of the shop by itself, without the exact time, does not lead to a conclusion that it was only the accused and only the accused who visited the shop during the closing time of the PW8. May my lord see the statement of PW8 again, my lord? This is important, my lord. Page 84. Just to refresh the memory, my lord. He says 7 to 7:30 when I was closing the shop. Then he says in the defense, page 84, first of all, he said 7 to 7:30 that accused purchased some things. Then he says that police asked me whether he has seen any boys. Then he says he remember one boy who came with the shop to the shop with blood in his right hand while receiving cigarette. And thereafter he says it is the accused the accused standing on the dock was the person whom I had given cigarette. Then later on in his defense, he says he does not remember the face of the boy who purchased a cigarette.
Another thing probably you didn't point out the other day. I'm not very sure.
Yes.
The re-examination in chief, the accused was not produced before me.
Yes, there was no TIP.
So you didn't mention it earlier, but I think
Yes, I was about to, my lord, now.
it will be very relevant.
Yes. So he says that according to if we take the statement in toto, we cannot say for sure that this is the person who had come to his shop. It is a shop. It is not a house that only one person will come. There may be many persons. There is also one thing which I would like to point out regarding the improbability of this, my lord. Because according to the prosecution statement, according to a statement of the IO, I'm not going to read it, but just going to repeat it again, that the sequence of events was like this, according to the IO. The accused killed the deceased, threw the knife away in Sunday Market area. Thereafter, after coming out from the shop of PW5, he did that. He met the deceased on the way. Thereafter, threw away the knife. Then thereafter, went to the shop of PW8 to buy some cigarettes and stuff. Thereafter, he went to one house of one nursery who is not a witness here, and has stole a long pant from there, washed his t-shirt, threw away the long pant in Kameng River, washed his t-shirt, and then left from that place. Now, my lord, somebody who has stabbed someone multiple times, according to the prosecution, multiple times, if he had the sense to wash himself, would he not wash himself first before going to the shop? Why would he expose himself that way? It is totally unbelievable and improbable for a normal human conduct, unless he's somebody that stupid. If he had the sense to wash himself, why would not he have done that earlier? So that makes the story of the statement of the PW8 also unreliable, not because I'm not saying that he's an unreliable person. I am saying that he might have been mistaken because there may be some other persons who came to his shop. And according to the police also, as per the IO, when the accused came to the shop of the PW8, he had blood on his face, neck, and hands. But according to the PW8, the blood was seen only on the right hand. So that also makes the story very improbable, because If he said that to the police, if he said that before the police, why would he not say that? If somebody was covered in blood, if somebody had just killed someone with one stroke or with one bullet, then there may not have been so much blood. But with so much of stabbing, there will be blood. And in such a state of blood, is it possible for somebody to expose himself like that? That is the question I'm raising, my lord. And also, my lord,
He is the alleged killer, not the person who has been killed. More blood will be on the body of the person who is killed.
of course, my lord, but at least some blood will be there. Some blood will be there. What I'm saying is, as a normal person, God forbid, if we do something like that, we will also not behave the way it is projected that he has behaved. It is quite improbable, in my humble submission. Another thing which I'd like to point out, according to the IO, at first there was no intention to kill. He just happened to meet the deceased on the way, and then he produced a knife. And then from where the knife was produced, that is also not there in the evidence. If somebody has a plan to kill somebody, of course he'll be carrying knife. But that part is not explained anywhere. He produced a knife, he killed the person, and then he threw the knife in the Sunday market. Now, Sunday market is such a place where that was also supposed to be have held the next day itself. A knife which is thrown in a public place. How is it possible that no one would notice?
That was a little bit surprising.
Yes. How is it possible that no one will notice at all? And in fact, in the statement of the IO, he has said about sending the of the FSL and all. He has said that he has sent he has sent the T-shirt of he has sent a long pen or something like that, but the long pen was not recovered. The T-shirt was also not the. We can't say whether it is that same T-shirt because it was recovered after many days. Another thing, my lord, coming back to the findings by the court. One of the findings by the court is that one very important ground, it seems the court has taken, according to the court, that PW12 and PW17 had met, before PW12 and PW17, the accused had met extrajudicial confession. PW12 is the brother-in-law of the deceased. In the 161 statement, he has not stated this at all. It is not in the records, but I have, in my appeal petition, it is at page 71, 161 statement of the PW12. So far as PW17 is concerned, he is just a seizure witness. He was not even a material witness at that point of time, but for some reason, it is said that it was confessed before him. Now, my lord, regarding this, I would like to place some citations, my lord. Because the circumstance, we can see from the statement of the PW13, who is the wife of PW12, that and also from the statement of PW17, that the confession, so to say, that the so-called extrajudicial confession was made when the accused was in the custody of the police. Because before the accused came back to Balokpur, the accused did not meet the PW12. From the, it is not clear from the statement of PW12, but PW13 says that the accused made a confession before the PW12 in front of the police. In this regard, I would like to place some citations, my lord.
Yes.
I had given the list of books. Oh. Lordship, I have this. Para 51. May I read, my lord, or will it take so much that my lord can see later on otherwise?
Para?
Para 51. Para 79 to 92. This is regarding extrajudicial confession. Then para 96 and 97. This is regarding the absence or presence of motive. Then para 103 to 107. This is regarding any explanation or false explanation if made under 313, and if that can be relied on in the absence of any other thing. I will, my lord, just read para 92, my lord. Sorry, page, para 88 also. Para 88. This will be at page 549.
Yes, an extra confession.
Yes, an extrajudicial confession, if voluntary and true and made in a fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of the evidence as to confession, like any other evidence, depends upon the veracity of the witness to whom it has been made. The value of evidence as to the confession depends on the reliability of the witness who gives the evidence. It is not open to the court to start with a presumption that extrajudicial confession is a weak type of evidence. It would depend on the nature of the circumstances, the time when the confession was made, and the credibility of the witness who speak to such confession. Such confession can be relied upon, and conviction can be founded upon if the evidence under the confession comes from the mouth of the witness who appears to be unbiased, or even remotely, or not even remotely inimical to the accused, in respect of whom nothing is brought out which could tend to indicate that he may have a motive for attributing untruthful statement to the accused. The words spoken by the witness that are clear, unambiguous, and unmistakably convey that the accused is a perpetrator of the crime, and nothing is omitted by the witness which may militate against it. Then, my lord, para 92. The sum and substance of the aforesaid is that an extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with great deal of care and caution. When an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses its importance, like the case in hand. The courts generally look for independent, reliable corroboration before placing any reliance upon an extrajudicial confession. Then, my lord, the next one, also an extrajudicial confession, but there are certain things which may be similar to this case. 1999, 7 SCC 714, para 23 to 26.
You don't have a printed copy?
This, lordship, actually my SCC online crashed down. I could not get it. Otherwise, I would have.
Could you just repeat 19?
This is 1999, 7 SCC 714, para 23 to 26.
Is on which point?
On extrajudicial confession, on the circumstances under which it can be taken. Para 23, the next important aspect is the credibility of the person who spoke about the confession. He is a taxi driver and no part of the evidence records that he has a clout with the police. It is not in evidence as to the period of friendship between the accused and the witness. Indeed, a very close friend may be taken into confidence and a confession affected. Commission of a offense of rape on a minor child and thereafter eliminating the victim from this world could not have been talked of or discussed with any and everybody so casually. There must be some cogent reason for making confession of this nature. The only reason available in the evidence for affording an occasion to make confession is that the accused used to drive the car of a son, and as such he used to park his car in the same parking area where the witness was also parking the car. In our view, this piece of evidence does not inspire confidence as to the credibility of the witness. The choice of a person to confess cannot be affected just like that. Para 25, in this context, strong reliance has been placed by the High Court in the decision of this court in case of Makhan Singh versus State of Punjab. The court, while dealing with more or less similar situation, para 11 observed on 10/8/1985, a fire was lodged by Nihal Singh, and on 13/8/85, the appellant went to Amrik Singh to make an extrajudicial confession. Amrik Singh says that the appellant told the police that after he had come and confessed, so that he might not be unnecessarily harassed. There is nothing to indicate that Amrit Singh was a person having some influence to the police or a person of some status to protect the appellant from harassment. In his cross-examination, he admits that he is neither the Lambadar or Sarpanch nor a person who is frequently visiting the police station. He further admits when he produced the appellant, there was a crowd of 10 to 12 persons. There is no other corroboration. There is no other corroborative evidence about the extrajudicial confession. As rightly considered by the learned counsel for the state, that extrajudicial confession is a very weak piece of evidence and is hardly of any consequence. The counsel, however, mainly relied on the motive, the evidence of last seen, and the evidence of recovery of dead bodies, the conduct of the appellant in not making report about the missing father and son. The confession in normal course of events are made to avoid harassment by the police or to a person who could otherwise protect the accused under such harassment. Then also in the last portion of the paragraph, there is about delay in recording the extrajudicial confession. Wholly unconnected with the police is a matter of great suspect. So the circumstance under which this confession was made, my lord, it cannot be ruled out, my lord, because the PW 17 has stated in his that he heard the confession when the confession was made, when the police was recording his statement. So that means the confession was made before the police, which he happened to have heard. This is not a piece of evidence that can be relied on, my lord. Also, the same fact is told by PW 13 that the PW 12 heard the same when the confession was being made to the police. Lordship, so sorry, my lord. I would like to revert back to the earlier citation, para 79, which I have given a printed copy of.
So right, we'll go through it.
Yes, my lord.
Okay. Do we have-
This is regarding whether it is also important when the confession is made, whether the accused was a free man. This is one of the circumstances which the court should take into account, para 79 and 80. My lord may see this later on.
Yes.
Then, my lord, the circumstances the chain of circumstances which would have been, my lord, the duty of the prosecution to complete. First of all, my lord, they have said the time of the incident, which I have pointed out, it is not clear at all. Then the accused leaving Balakpung only after 6 p.m. That is not based on any records. That has come out from the mouth of the court only by a process of making a khichdi of the time of the incident, only basing on it saying that the accused left Balakpung only after 6 p.m. and not before that. Then another circumstances which the learned trial court has said is the motive. But it has come from the mouth of the witnesses that although there was some sort of quarrel between the deceased and the accused, that matter was compromised. Not one, not two, but several of the witnesses have stated that. So the motive in any case is just one of the circumstances if the other things are proved. Then court also relied on that hearing of a sound by the PW3 and PW4. But this is not true, my lord, because it is only the PW4 who said that he heard the sound. PW3, on the other hand, did not support him. So that is not true. But in the judgment at page 146, this has been said to be one of the circumstances that PW4 and PW3 have heard the sound of somebody running away. This is not just a wrong finding. This is a wrong fact recorded, my lord. It cannot be a finding at all because the fact itself is wrong. Then like I said, the extrajudicial confession. One of the grounds that the learned trial court has relied on the extrajudicial confession is that when the accused was asked under 313 about this, he had admitted. That is also what is stated in the. That is not true, my lord. May I see the 313 statements, my lord, again.
What to do?
That would be page 69 and 71.
No, either we continue today on first class, then single bench will
Most times it will not happen that way.
I will have to keep it for either thing.
We are short of time actually, Ms. Dungan, and we have to hear the PP also. But we'll do one thing, we'll have it again tomorrow.
My lord, I'm really sorry. I have some very urgent work tomorrow.
You have
That is-
completed your part, we'll hear the PP, then we'll close it up.
Lordship, there are just, if my lordship may give me just 15 minutes, my lord.
No, I mean, you have completed, I mean, we have
Uh,
everything. What else is there? You have already read out the whole.
I would like to point, my lord, in that case may record that the answer to the 313,
You can
Of
give
this
it- give us
witness.
in writing also if you want to.
You can give a written
Ah.
thing also if you want.
We have to rise now because
my lord, in that
No,
case, I may
that-
not be available tomorrow, but I will send,
you send somebody, you send in writing whatever point you want to make.
I have almost completed except for the citations
Hmm.
and one or two points here and there.
Citation you can give, and in addition to that, if you wish to,
Yes,
then you can give this written thing also, as you wish.
I will give the written thing. Don't want to miss out
And
anything.
we will hear Mr. Ete.
Tomorrow, my lord,
Yes.
Tomorrow.
Tomorrow.
I'll try, but
Because yesterday the matters could not be taken up. Yesterday because of the ban.
yes,
APP, this thing was there. I mean, APP was there. So all the bail matters we have fixed today. So
yes,
we'll have to take up those urgent matters.
yes, I
How
understand, of
long
course,
will
my
it
lord.
take, PP?
Well, I will hardly take much time because my lord, I will just point out the PWs. I will not read out even their statement because my lord has already perused their statement, and my learned senior colleague has also read out the statement. See how the chain is completed. Only I will point the PWs, and I will just reiterate the 313. That's it, my lord. Nothing much in this case, my lord, because
Even you may like to give in writing if you want to. The points which you're going to say,
yes, my lord.
not the entire story, the points which you would like to refer to if you want to.
Yes, my lord.
Otherwise, we'll hear you because
Yes.
tomorrow will not take much time. It's only your part that has to be completed.
Yes, my lord.
Ms. Dungan will give us something in writing what she wants to.
My lord, I will
Right.
just summarize. I can give in writing that which this prosecution witness are relied by the prosecution, and basing on which the chain is completed, and why 313 has to be taken into consideration, and what law says on that aspect, my lord. And extrajudicial law will clear it because mostly, my lord, our argument is on motive and motive conduct, my lord. And 106 will also come in this case, my lord. Although it's not a last in theory case, by your lord.
Right. List again tomorrow as part of it. Then I think that takes care of the list, DB list. Okay. Second half, we're setting single.
Wait,
May,
Ajal bench, item number 1.
may it please your lordship, my lord. My lord.
Mr. Das,
I'm sorry.
you have any, you want to mention anything?
My lord, there is a matter which is item number 19, my lord. 19. But I have told and I have talked with Mr. Pawan Tiwari. He is not well, my lord. He is not well. Your lordship just recollect this matter was fixed with consent of the
Yes.
party, but he's not well, my lord. So, so I didn't trouble myself to come to the Arunachal Pradesh. So with his consent and my consent, if it is not inconvenient to your lordship, can it be on 16, my lord?
Item 19.
19.
Item 19.
19. It's a contempt matter. Yeah.
Yes, correct, my lord. On 19, can it be fixed on 19? 16,
All right,
sorry, my lord.
please.
16, 16.
16, okay.
16.
All right, as paid for by the parties, list the matter on 16th of December 2025. Item
My
19,
lord,
okay?
yes, it can be on an admission column, my lord. Admission, my lord.
One more line, you continue, as paid for by the parties in the admission column. Okay.
I am deeply obliged, my lord.
All right.
Deeply.
May I please your
Yes,
lordship?
yes.
My lord, this is bail application. This application is listed for the second time. That, my lord, the applicant had submitted a bail application before. However, your lordship had rejected the application. And my lord, thereafter, we had filed this application again on the grounds that there is violation of Article 22(1) of the Indian Constitution. And also, my lord, there are some new developments with regard to the trial. That violation of Section 42 of the NDNPS Act is established. That, my lord, those, and apart from that, there are some medical grounds that we are praying for release on bail. Those are the main 3 grounds that we will be submitting today. Then, my lord, the accused were arrested on 4/7/2023 at 10:30 p.m. for alleged involvement in connection with seizure of 4.378 kgs of...
No, see, the factual aspects, I think you need not submit.
Yes, my lord.
You just submit on the grounds for bail.
Yes, my lord. Our first ground is the violation of Article 22(1) of the Indian Constitution. Then, my lord, if I may take your lordship to the application of the arrest memo and the seizure memo, which is at page, arrest memo is at page 27. Then, my lord,
27.
Page 27, the arrest memo. My lord, the second last paragraph. If I may read.
Yes.
On reasonable belief that Sri Lalyanthanga, my lord, this is the instant applicant, 33 years, son of Larindika, resident of Zokomoi, so-and-so, has committed an offense under Section 8C of the NDNPS Act 1985 as amended, which is punishable under Section 22 and 23 of the NDNPS Act, and he is hereby arrested in exercise of the powers conferred under Section 42 and 43 of the NDNPS Act as amended. That, my lord, here in the arrest memo itself, there is complete violation of Article 22, that intimation of reasons of arrest or grounds of arrest is complied as per the mandate of Article 22. And also arrest intimation was not given to the relatives or anyone of the accused. And also, my lord, if I may take your lordship to the seizure memo. And at page 23. My lord, at page 25 is the retyped copy.
Okay.
Here, my lord, by whom seized? Shri Kevin so and so. Lamsam 1. Date and time of seizure 4/7/2023 at 22:30 hours at Sangtia Hotel, Trumpui, Aizawl. The custom case and the details are there. Here in the seizure memo as well, there is no documents on record to show that Article 22 has been complied with. Also, my lord, if I may take your lordship to the deposition of the case IO at page 95.
95.
Yes, it starts from 94. However, my lord, the operative portion is at the cross-examination, which starts from 100. But the operative portion is at page 101, the last paragraph, para 11. It is a fact, if I may read, my lord.
Yes, read.
It is a fact that I personally did not see the accused carrying the said jute bag, which was allegedly used for keeping the essay while they were entering Hotel Sangtia, even though we saw them entering the said hotel. I do not remember whether the personal bags carried by the accused persons were seized or not in the present case. However, the photographs of the said bags were not included in the charge sheet. As far as my knowledge, the said bag was not seized from the physical possession of the accused persons. It is a fact that there was no document to prove that the bags from which the essay was allegedly recovered were belonging to the accused persons. It is a fact that I do not enclose any photograph in the charge sheet which shows that the contraband drugs were seized from the above mentioned bags. That, my lord, the accused persons were not informed as to why they were arrested or they were detained for so long. And that, my lord, this is the cross-examination of the case IO, Mr. Saitluang Asailao, and which clearly established that no grounds of arrest, reasons of arrest, or intimation was not given to the accused persons. And also, my lord, and the next grounds is violation of section 42. Well, my lord, they are in the first bail application. Section 42 violation was already established.
Yes.
If I may, may I read or not, my lord? Is it required?
Read what?
Your lordship's judgment regarding section 42 in the previous bail application.
You may point out which paragraph is it?
My lord, it's at page 129, para.
Is it paragraph 5? Can you hear me? Some technical glitch. Page 90. Yes, memo. So it's in section 42. Call somebody. We will do one thing. We'll list again tomorrow. We
I,
can't wait like this.
my lord, we can hear you.
Oh, you are there,
Yes, my
but
lord.
I can't see you.
My
I
lord,
can't
yes,
see you.
we cannot see you. There's a power shortage here, and they've put on the generator, and the system is setting up. Now we can see you.
She's from their side, my lord.
Okay. They're setting it up.
Yes, my lord. My lord, if I may continue with my submissions, if your lordship.
Yes, I can hear you, so you may continue. All right.
Yes, my lord. My lord, the operative portion, I'll make it fast. The operative
Yes.
portion is at page 133 at para number 7. The explanation under section 43 of the NT-NPS Act provides that public place includes any public conveyance, hotel, shop, or other place intended for use by or accessible to the public. The learned counsel for the applicant has tried to impress upon the court that hotel may be a public place, but the room of the hotel may be a public place as per the judgment of the apex court in the case of so and so. However, in the instant case, materials available on record go to show that the applicant and another person had just entered the hotel concerned and were immediately followed by the custom personnel who identified themselves to them. It therefore cannot be said for sure that the room had been indeed allotted to the applicant and the other person, and that they had checked in after completing due formalities. Further, the arresting authority had also taken down in writing the information received by him about the likely sale of some quantity of contraband suspected to be methamphetamine to happen at Hotel Sangtea by 2 Burmese nationals. The applicant admitted is a Burmese national, and the apprehension of him jumping bail is found to be relevant. My lord, that with regard to this, there is after the disposal of the first bail application, there are some new developments. One, prosecution witness from the police, Mr. Dhyan Singh Minhas, was examined. My lord, the deposition of Mr. Dhyan Singh Minhas is at page 105. My lord, the operative portion is at page 106, cross-examination, para number 3. If I may read, my lord has got it.
Yeah, read.
It is a fact that the seizing officer conducted search inside the hotel room occupied by the accused persons at 9:30 p.m. That, my lord, it is not just the hotel lobby or the hotel in general, which is accessible for all the general public. This is specifically allotted to the accused persons. It's a private room. And which is
paragraph?
Then, my lord, at para number 3, cross-examination by the counsel for the accused persons.
And page
106 of the application.
106 is missing in my copy. 106 is not there.
My lord, if I may read again.
Yes.
It is a fact that the seizing officer conducted search inside the hotel room occupied by the accused persons at around 9:30 p.m. Then, my lord, it is clear.
This will be paragraph number
3 of the cross-examination. And also, my lord.
Problem is that page 106 is missing. I have 105, then it goes to 107. So anyway, you'll have to arrange that to send.
Yes, my lord.
To ask somebody to send it.
Yes, my lord.
And any other point?
my lord, my lord, there are some medical grounds,
Yes, which is?
which is some difficulty with his kidney,
Any
the
certificate?
urinary tract and the kidney problem he has.
UTI? Any
Yes,
certificate?
not just UTI. Yes, my lord. It's at annexure number 6.
Page?
Page 1. It starts from page 136, my lord.
Yes.
My lord, there are so many tests to be done. However, due to shortage of prison staff, then some persons cannot be taken care of their health for medical checkup. And that also, my lord, that in my conclusion, that there are violations of Article 21, the right to personal liberty, and Article 22, that the rights and the grounds of arrest and the reasons of arrest were not informed. And then, my lord, we had submitted some citation
Did they?
regarding.
Citation?
Yes, my lord.
What is that citation? Could you?
Then, my lord, we had submitted Prabir and Vihan and Mihir Rajesha, and with regard to section 42, we had submitted Karnal Singh.
So is it annexed to your bail application or separately?
No, we had submitted this morning, my lord. We had
Then it
submitted
has not been
in
sent
the
to.
ISOL bench to the bench assistant, and it
So
was conveyed to your lordship's
No,
bench.
it has not been conveyed to me. I don't have it.
My lord,
You take it up
not-
again.
Yes, my lord.
You
to-
take it up again with the registry to send the citations as well as page number 106.
Yes, my lord.
Okay.
I will do that. Also, my lord, if I may take your lordship's attention to the bail order of the co-accused, David Lala, at
Where's
page
that? Page number?
149.
Hmm. Yes, 149. He's the co-accused.
Yes, my lord. He's the co-accused. They were arrested at the same place, same time.
Okay, I'll go through it.
My
Anything
lord,
else?
Yes, my lord. If I may read, do I need to read the?
You're not required. I'll go through it.
Yes, my
Since
lord.
we are short of time,
Yes, my lord.
I'll go through it and consider.
Yes, my lord. My lord, so in my conclusion, if the instant applicant be released on bail for violation of Article 21 and Article 22 of the Constitution of India in violation of 42 of the NDNPS Act, and we are
Okay.
invoking the doctrine of parity as the co-accused is already released on bail.
Okay. So I'll request you to take it up with the registry to mail me your citations
Yes, my
and
lord.
page 106 of the bail application.
Yes.
Okay.
Yes, my lord. Yes, my lord.
All right. So let me hear Mr. Johnny.
Lordship. Lordship,
Yes.
the petitioner had already preferred to submit a bail application 3 times. The first and the second bail application were preferred before the Learned Special Court and the NPSA, Lordship. And the third one before the Honorable Court, and all of them were rejected. And Lordship, White order dated 8/5/2025, this Honorable Court, while rejecting the bail application of the accused, it had clearly expressed that the petitioner is the Myanmar nationalist, and the apprehension of jumping bail was found to be relevant. Lordship, in this context, it is still very much relevant, Your Lordship. And since he is not having any relatives in India, and there is a reasonable chance to abscond, Lordship, that is very much relevant, which Your Lordship had earlier considered the submission of the PPL, Lordship, and which has been clearly found at page 134 of the this petition, Your Lordship. And regarding the second point, Your Lordship, this matter is regarding the recovery of the huge quantity of the methamphetamine, which is 4,378 grams of the methamphetamine, which is a commercial quantity, Lordship, and which has been booked under 22C of the NDNPS Act. And there is a stringent provision, which is section 37 of the NDNPS Act, Lordship. Then the bail may be granted by satisfying the twin conditions, which has been prescribed under section 37 of the NDNPS Act, Lordship. And the first one is if the Honorable Court, if satisfied that there is a reasonable ground to believe that the petitioner is not guilty of such offense. And the second one is if is not likely to commit any offense while he was released on bail. Also, it's very clear that either of these two conditions is not satisfied, and the accused shall not be released on bail. In support of my submission, Lordship, I would like to rely on the 2007 SCC 798.
Name of parties?
Name of the parties: Union of India versus Shiv Shankar Kesari. The relevant paragraph is paragraph 5, 6, and 7, Your Lordship. May I read?
Would you like to read it?
Yes, Lordship. I'll read the relevant paragraph, paragraph number 6 only, Your Lordship.
All right.
As the provision itself provides that no person shall be granted bail unless the two conditions are satisfied. The two conditions means, Your Lordship, section 37. They are the satisfaction of the court that there are reasonable grounds for believing that the accused is not guilty and he is not likely to commit any offense while on bail. Both the conditions have to be satisfied. If either of these two conditions is not satisfied, the bar operates and the accused cannot be released on bail. So there is a strict provision, which is section 37. And, Your Lordship, regarding the section 42, which my learned friend had submitted, there is no violation of section 42, which Your Lordship in the earlier bail application had thoroughly considered that there is no violation of section 42, which has been found at Lordship, page 132 of the petition, Your Lordship, section 42.
Okay, but what do you say about page 106?
Page 106, Your Lordship, there is nothing to show that there is a violation of section 42, Your Lordship, from the reading of page 106, paragraph number 3.
Search was done from the room
Yes.
allotted to the accused persons. That is what was read to me. Yes.
And Lordship, as per my understanding, there is no violation of the section 42.
Okay.
And regarding, Lordship, this grounds of arrest, we have informed the grounds of arrest to the accused person. May I take, Lordship, to page 58 of the application. This is a statement of the Caesar witness. The operative is at page 58, second paragraph. May I read, Lordship?
Yes. Read.
The methamphetamine was put in polythene bag and sealed with Bongkon police station brass seal after preparation of Caesar list. The witnesses, two owners of the methamphetamine, customs officer and police officers put our signature on the sealed packet. After completion of the seizure, we, the witnesses, the owners of the methamphetamine, police officers and customs officers approached Customs Office Chanmari, Aizawl, and reached the Customs Office at around 05/07/2023. The customs officers interrogated the owners of the methamphetamine and then arrested Lalianthanga and David Lala as per NDNPS Act 1985. Lalianthanga and David Lala were given copies of their arrest memo, were also made to put their signature. The customs officers also informed them the grounds of their arrest and also made them inform via phone call the residents of Aizawl who were known to them that they had been arrested. So there is no violation of the Article 21 and 22 of the Constitution of India. So in this regard, I'd like to rely on 2024 7 SCC page 599. 2024 7 SCC page 599, paragraph number 23. Paragraph number 23.
Yes, read paragraph 23.
Yes, Lordship. As discernible from the judgment in Pankaj Bansal case, also noticing the inconsistent practice being followed by the officers arresting the persons under Section 19 PMLA, directed to furnish the grounds of arrest in writing as a matter of course. Henceforth, meaning thereby from the date of pronouncement of the judgment, the very use of the word henceforth implied that the said requirement of furnishing grounds of arrest in writing to the arrested person as soon as after his arrest was not mandatory or obligatory till the date of the said judgment. The submission of the learned senior counsel, Mr. Sessions Judge, for the appellant that the said judgment was required to be given effect retrospectively and cannot be accepted when the judgment itself states that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exceptions. Hence, non-furnishing of grounds of arrest in writing till the date of pronouncement of the judgment in Pankaj Bansal case would neither be held to be illegal nor the action of the officer concerned in not furnishing the same in writing could be faulted with. Lordship, here, this Pankaj Bansal case was decided on 3rd October 2023. And this arrest was made on 4th July 2023, which means that this arrest was made prior to the judgment of this Pankaj Bansal case. So it means that the grounds of arrest in writing was not mandatory at the time when the petitioner was arrested by the customs officers. So we have informed the grounds of arrest to them, and we have also informed their relatives through telephone. So there is no violation of 21 and 22 of the Constitution of India. And regarding the medical certificate, Your Lordship, so they have...
Before that,
Lordship, yes.
Before that, what is that citation? 2024 7 SCC?
7 SCC, page 599.
Yes. What is the name of the parties?
Ram Kishore Arora. Ram Kishore Arora versus Directorate of Enforcement.
Okay.
And regarding, Lordship, the medical certificate, so they have annexed the UTI and whatnot, Your Lordship, but there is no life-threatening and no certificate from the central there stating that the accused is not fit to be in the judicial custody. So, Lordship, the stringent provision, section 37, is very clear. And regarding the co-accused has been already released by this honorable court, the coordinate bench, though it has been released by the coordinate bench of this honorable court that does not bar this court, Lordship. So this honorable court may have different findings also. It does not bar a Lordship. So the bail petition may be rejected.
That's all?
That's all, Lordship.
Okay.
My lord, if I may be given few minutes to reply to the learned PP.
Yes.
My lord, the learned PP had said that there is no violation of Article 22, and they have not. There is nothing on records. There is no material available on records to show that they have complied with Article 22. And until and unless they have to prove, the prosecution has not proved the case beyond reasonable doubt. And therefore, my lord, with regard to the possession or the owner, nothing was done. And if foundational facts is not established by the prosecution, then the burden of proof is not on the accused persons. And in this case, they have not done so. And also the prosecution has not provide anything on records to show that they have complied Article 22. It's just a mere submission or a plain reading of the charge sheet doesn't prove anything of compliance of Article 22. And the mandate is clearly described in Vihan as well. In Vihan and Prabir and my lord, which we have the recent judgment which I have submitted in the Mihir Rajesh. And also, my lord, with regard to Pankaj Bansal, and that it's not applicable in this case, my lord, if I may place reliance on one Supreme Court ruling, 2025 INSC 278, Kanish Sinha and another versus the state of West Bengal and another.
No.
Here, my
Go
lord.
slow. Repeat again.
Here, my lord.
Please repeat it slowly again, the citation.
2025 INSC 278. Kanishk Sinha and another versus the state of West Bengal and another.
Okay.
Here, my lord, the operative portion is, if I may read, it's at para number 3. Just one sentence, if I may be allowed to read, regarding,
yes,
it's the principle of law that the laws laid down by the Supreme Courts, it goes retrospective. And this is also a reportable case. My lord, I'll read. Now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature, unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by the Constitutional Court, or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature, unless the judgment itself specifically states that the judgment will operate prospectively. Then, my lord, in the judgment, in Pankaj or Vihan or Prabir or in any of the judgment, it's not specifically mentioned that it shall operate prospective. So that, my lord, the law which is laid down by the Supreme Court will be applicable in this case as well. So that is my submission. This also, my lord, I will give it in my citation list.
Yes, do that. That's all?
Yes, my lord. I think, my lord, I have replied, rebut to all the submissions made by the learned PP.
All right. Please write down. Heard Ms. Lalngai Sakifan Rai, learned counsel for the applicant, and Mr. Joniel Tochong, learned special PP, customs. Order to be passed separately.
Deeply obliged.
You get the citation sent immediately. So
Yes,
order
ma'am.
will be passed. All right.
Yes, my lord. Deeply obliged.
Item number 2.
Yes,
Followed
Mr.
here in
Modi,
this case,
there's one more. There's one more case.
May I please, Your Lordship?
Yes.
Your Lordship, bail application for Abdul Majid, NCB case number 8 of 2023. Your Lordship,
Yes.
the accused has been languishing in judicial custody for more than 2 years, 2 years, 7 months, and 9 days. And Your Lordship, on 30th October 2025, the co-accused Parul, he got the bail from the Honorable NDNPS case. Your Lordship, today is the first day, that is the date of the admission. So, Your Lordship, it's our prayer that we have filed a bail application based on the parity ground and detention, and also based on the ground that the violation of Article 21, as under Article 21 of the Indian Constitution, guarantees fair and speedy trial. But since Your Lordship, as best of our knowledge, there are 9 prosecution witnesses, and out of those, only during this prolonged period of detention, only 5 has been examined, and 4 are yet to be examined. It's taking too much of time for this entire trial to get completed. Also, Your Lordship, the ground of arrest were not explained to both the accused and the family members, which is also a violation of Article 22 of the Indian Constitution.
Okay, see, your application was earlier rejected by this court, isn't it?
Yes, Your Lordship. That
This
was
second time.
last year, Your Lordship.
And this application, second application has come for the first time.
Yes, Your
So notice will have to go by this
Yes,
stage.
Your Lordship.
Who is appearing for the
Your,
state? You are appearing through VC.
yes, Your Lordship. I'm appearing through VC from Guwahati, Your Lordship.
From Guwahati.
Yes, Your Lordship.
Okay. Now, thing is that can it be taken up some other day?
Your Lordship, on the next date, we will be present physically there. Actually, we got a notice yesterday only. That's why it was difficult for us to go there.
No, thing is that matter pertains to the Aizawl bench.
Yes, Your Lordship.
And the vacation starts from
Your
15th.
Lordship, we pray any date after the vacation, immediately after the vacation will.
So we have to fix it on reopening.
Yes, Your Lordship. Highly obliged, Your Lordship.
All
But
right.
immediately
What's
after.
your good name?
Your Lordship, my name is Lubna Chaudhary. Lubna Chaudhary.
Okay, please write Heart Miss Lubna Chaudhary, learned counsel for the applicant through RVC, who submits that this is the second time the applicant has sought for bail. Issue notice returnable by. We don't have a calendar, Alexius. See, we don't have the calendar of Aizawl bench immediately, so we'll fix a date later on. Returnable by so and so.
Obliged, Your Lordship.
Petitioner applicant to serve notice to the state. How will you take steps? No one is appearing for the state.
Your Lordship.
How will you take steps? Somebody has to appear for the state, isn't it?
Yes, Your Lordship. Your Lordship, before this session, this VC started, we have
See-
received a call from the PP of the state. They have also informed us that we have to serve a notice.
Yes.
Maybe you-
Applicant to serve notice to the state through the Office of the Public Prosecutor, Mizoram.
Obliged, Your Lordship.
Within? Do you have any local counsel there?
Yes, Your Lordship, we do have.
Is there a public prosecutor available in Guwahati for the state of Mizoram? Or you contact
Your
someone
Lordship,
there?
I'm not aware of.
You have to serve notice to the state through the Office of the Public Prosecutor, Mizoram, within 1 week.
Obliged,
And
obliged, Your Lordship.
a copy of the acknowledgement receipt be submitted before the registry as proof of service. List again on so and so. We'll list it sometime in
Obliged.
January on reopening. Okay.
Yes, obliged, Your Lordship. Your
Right.
Lordship, if possible, 14th of January.
But we don't know, na, whether when it reopens there. We'll check out the date, calendar, and give the date.
Sure.
Okay.
Your Lordship, we already have a matter fixed on 12th of January in Aizawl bench.
On which date?
On
On which
12th
date?
January 2026. On 12th January 2026, we already have a matter there in Aizawl.
Court is reopening on which date?
Your Lordship, probably on 12th itself.
No, but you don't know, no, because this court may not be there in Aizawl also. And this court may be
Okay, Lordship.
governed by the holiday list in Guwahati, not Aizawl. So that problem is there. I'll give you a date later on.
Obliged, Lordship. Obliged, highly obliged,
All
Lordship.
right.
You'll take a break.
No, I'll continue.
Adjourn. Mention करना.
Vanessa, this is sent to my chamber. And the first case, not some citation they'll send through mail. Send it to me. So, and both the files will go to my chamber only. Okay?
May I submit, my lord? May I submit, my lord?
Yes.
Lord, I beg to mention one unlisted item, my lord, to be listed tomorrow, my lord. Yesterday it was listed, my lord, but I could not attend, my lord, due to the bond call, my lord. This motion item, my lord.
Which matter?
It is WPC number 577
It was listed today?
Yesterday, my lord, it was listed, my lord, but I could not attend, my lord. This is tender matter, my lord. So, my lord. I pray matter be listed tomorrow, my lord. I am praying for listing of matter tomorrow, my lord.
Urgency has to be mentioned, you see. Just because it's tender matter, it doesn't mean that it's urgent.
My lord, I already work has been awarded, my lord.
Demonstrate, what is the urgency?
My lord, yes, work has been already awarded.
Somebody mentions today that this matter be listed tomorrow. Court asks what matter? Is it service matter?
Yes, my lord.
Is it urgent?
Yes, urgent, my lord. In the sense, my lord.
How it is urgent? Demonstrate.
Yes, my lord. It, my lord, already, my lord, work has been awarded a third party, my lord.
Huh?
Already work has been awarded a third party.
Already awarded, that means it's not urgent.
No, I am praying some interim, my lord.
If you say it is going to be awarded any moment now, then it becomes very urgent. But if you say already awarded, then...
Lord, I'm praying some interim order protection, my lord. That one. Tomorrow, my lord, is a...
All right, we'll see.
Oh, yes, man.
My lord, item number 6 to 8.
6 to 8.
Yes, because of the pendency of the petitions, my lord, promotions are not being, my lord, DPC is not being held. And my clients, most of them will retire by the end of the year. That is the difficulty. So we're praying for some accommodation tomorrow, if time permits, madam.
Tomorrow.
But I am put a
Today I'm
petitioner.
trying to understand there is another part heard matter, madam.
Yes, part hard is there. Time factor is there.
Yeah.
Tomorrow again, we have division bench.
Already almost 3 o'clock.
It was listed, my lord has fixed it as first item, this one also. Tomorrow, my lord, we are making for.
It's a first item, my lord.
If time permits, my lord, we will give it a try, otherwise.
There are 2 first items.
Yes.
The first item will be disposed of today, I suppose.
I don't know whether it will be possible or not.
We'll try today.
We have division bench also coming up again tomorrow.
Wait, otherwise, my lord, we will wait, my lord, we will try, take a chance today also.
All right, up to you. Yes.
Sir, item number 12. Well, otherwise it is matter for disposal, but I don't think Malad is likely to come up today. Let this matter come up after the ensuing due vacation, Malad.
Okay, as agreed to by the parties, let the matter be listed again. When? 19th?
Malad, say after Bihu vacation, we will make a mention, Malad.
After ensuing, after the Bihu vacation.
Obliged.
All right.
Lordship, I beg to mention item number 15.
Oh, I was about.
15.
Yes, on behalf of Itagum, Standing Council for Education. I've taken consent from all the parties that this matter be fixed.
When?
13.
Item 15.
No, 15.
After 20.
15 Lordship.
15 Lordship, this matter, Lordship, this is urgent matter, Lordship. So they failed to file their affidavit, Lordship. Here is the case, Lordship. Only NOC is not issued by the respondent authorities for processing of the pension paper, Lordship. However, Lordship, in this case, Lordship, charge sheet file, in charge sheet, Lordship, petitioners is exonerated in the charge sheet. So there is vigilance case is not required at all, Lordship. If there is no pending case against the petitioner, Lordship, in this case, Lordship.
All right, you're objecting to adjournment?
Not objecting, Lordship. List this matter.
After 20, Lordship.
Not after 20, Lordship.
Because
First week, Lordship. Reopening of the
because
of January, Lordship. Party, Lordship, is not much.
Reopening is 5th.
Yes, Lordship.
6th is holiday again.
Yes, Lordship.
Then 7th again is reopening, one more. 7, 8, 9. When do you want it?
Lordship. It's pension matter, Lordship.
You tell me the date. When do you want it?
Hearts, Lordship.
we have filed it.
Okay, Lordship, in 20, otherwise, Lordship, in 20, Lordship, no, if they are not filing, even if affidavit, Lordship, they can proceed, Lordship, in that case, Lordship.
Okay, as agreed to by the parties, let the matter be listed on 20th of 20 January 2026. Respondents to file a counter affidavit in the meantime.
Lordship, respondent number 2
has filed. I have filed, Lordship, already.
2 file. So, Lordship, in admission column, Lordship. May please, Lordship, in the admission column, Lordship.
2 has filed.
Yes, Lordship.
Others have not filed.
Yes, Lordship. They are not required, Lordship.
CBI is also there, Malad. I am for the CBI, Malad. CBI is not required to file, Malad.
Respondents to file a counter affidavit, if not already filed.
Yes,
list the matter in the admission column. All right, next.
And Lordship, item number 23. It is in the supplementary column.
There is no 23.
It is there.
Oh, who is supplementary? Yes.
With the consent from all the parties, let this matter be fixed after at least after 3 weeks. I am mentioning on behalf of Itagum, Standing Council.
Any objection, other side?
No, I've taken.
No objection.
Okay, as paid for by the learned councils for the parties.
Lordship, but this matter should be listed in order. This supposed to be listed in order.
Why?
Listed in admission.
Why should it be in orders?
Because in previous that respondent has to file affidavit, additional affidavit. They didn't file.
In the meantime, we'll file, it's okay, let it be in.
They can file, it's okay, there's no issue. This is the matter in after 3 months, after 3 weeks. On a date to be fixed by the registry.
My lord, may I mention?
Respondents to file their counter affidavit in the meantime.
My lord, may I mention item number 13?
Yes.
Here I am for the Respondent Union of India, my lord. My lord, may I pray that 4 weeks time may be granted. In the meantime, my lord will file affidavit.
Mr. Mao is there?
Yes, ma'am. I've taken the consent of the parties also.
Okay, how much time? 4 weeks?
4 weeks time.
As paid for by Mr. M. Katol on a DSGI, appearing for the Respondent Union of India.
Madam.
Further 4 weeks time is granted to file counter affidavit.
Madam.
List again after 4 weeks on a date to be fixed by the registry.
Madam.
Lordship, I beg to mention item 17 and 18, Lordship. This matter may be taken up after, Lordship, 4 weeks, Lordship.
Have you taken consent?
Lordship, he was the earlier counsel, Lordship.
Lordship, I was the earlier counsel in this case, but Lordship, I have given NOC to my client. So my associate name may be struck out from the cause list, Lordship.
Your good name?
T. Topu.
So they know about that, of you giving up. Then IS filed by whom?
That's Lordship, I don't, after giving NOC, I don't have any connection with my client, Lordship, that client.
Mr. T. Topu, learned counsel for the petitioner, submits that he is no longer the appointed counsel since he has given his NOC to his client. Stop. Ms. G. Atel, learned additional senior government advocate, prays for how much time?
Lordship, 4 weeks time.
Counter? You have filed?
Counter we have filed.
Prays for 4 weeks time to prepare the matter.
Lordship, my that associate name may be struck out from this cause list, Lordship.
Only your name?
My associate name is there, T. Topu, Togdok Tamin, El Kagung T. Pahe.
Name of Mr. T. Topu and his associates be struck off from the cost list.
Of lines.
One more line, issue notice to the petitioner. Registry to issue notice to the petitioner by enclosing requiring the petitioner to make alternative arrangement. Notice by registered post with AD. Next.
Your Lordship, I beg to mention item number 10. Here I am the petitioner, and I have received affidavit in opposition. I need some time to file a reply.
How much?
3 weeks.
As paid for by the learned counsel for the petitioner, 3 weeks time is granted for filing rejoinder affidavit. All right.
Lordship, I beg to mention item number 20.
20, yes.
Yes. Lordship, here I'm appearing for respondent number 4 and 5. Today itself we have filed wakalatnama for respondent number 5. 2 weeks time may be given, Lordship.
Your good name?
P. Moyong.
Today only you filed,
Yes.
but your name is already there in the cost list.
No, Lordship, we have filed wakalatnama for respondent number 5 today, Lordship.
4 also you are appearing.
Yes, Lordship.
Ms. P. Moyong, learned counsel, submits that she'll be appearing for respondent number 5 as well, apart from respondent number 4. And prays for how much time?
2 weeks.
2 weeks time to file counter affidavit. Praise the Lord.
Lordship, interim may continue. I'm for the petitioner, Lordship.
List again after 2 weeks. On a date to be fixed by the registry. Interim order passed shall continue till the next date.
Deeply honored.
Lordship, I'd like to mention item number 14, Your Lordship. Here we have to file affidavit, Your Lordship. 2 weeks may be granted, Your Lordship.
As paid for by Ms. Barbasa, learned state counsel.
My lord, kindly a fixed date may be given because my senior has to come all the way from Guwahati.
When do you want it? This year or next year?
22nd of January.
As paid for by Ms. Arbasar, learned state counsel. Further 3 weeks time is granted for filing counter affidavit. Stop. As agreed to by the parties, list the matter on
22nd of January.
22nd of January 2026. All right.
My Lordship. Lordship, in item number 20, I am representing respondent number 6. We have filed the wakalatnama for respondent number 6.
6. I already passed an order, 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. 20. Item 20. What is your prayer?
Lordship, we have not received the that copy of the WPC.
Your good name?
T Gao.
T?
T Gao.
Your name is not here?
Yes, Lordship. This morning we have filed the Wakalatnama for respondent number 6.
Spelling, what is your name spelling?
TANUR. Tanur Gao. TANUR.
Tanur?
GAO.
Geo. Okay, please write one more line at item 20. Mr. Tanur Gao.
Yes, Lord.
Learned Counsel submits that he has instructions to appear on behalf of respondent number 6.
Yes, Lordship.
And he has filed his power this morning.
And
stop. He also submits that he has not received a copy of the writ petition. But how did you get instructions without writ petition? How did the respondent number 6 come to know about this case?
Since Lordship, the 6 is MLA, and he has already met a Senate party.
So?
But however,
he must have received copy. Without receiving copy, how will he know that case is there?
Yes, Lordship, but it is reflected in the order, Lordship.
My lord, we have taken steps on the R4, then service 6 awaited.
6,
Yes,
R6.
We have taken steps by registered post. The service.
You provide one extra copy?
Yes, Lord.
What did I say last line? Okay, Learned Counsel for the petitioner undertakes to serve a copy of the writ petition to Mr. T Gao within 2 days.
Yes, Lord.
Okay.
In the meantime, Lordship will file our affidavit in opposition.
Please do that. Respondent number 6 is at liberty to file counter affidavit.
Yes. Deep lies.
Next.
Rather than mentioning item number 9 on behalf of Mr. Tara, praying for 2 weeks' time to file a rejoinder.
Okay, as paid for by the Learned Counsel for the petitioner. 2 weeks' time is granted for filing a rejoinder affidavit.
Yes, obliged.
Item number 1.
Yes, may I please, Lordship? Lordship, this writ petition is for taking direction to dispose of the representation dated 4th of the September 2025. Lordship, page number 73, Annexure 1, Annexure 6, Lordship. Page
73?
Yes, page 73, Annexure 6, Lordship. This is my representation. This representation is pending before the Director of Health Service, Government of Arunachal Pradesh, from last 4 months, Lordship. So nothing, any result is come out. Only our prayer is that request for promotion to the post of laboratory technicians from the post of laboratory assistant by extending one-time relaxations by counting first service as a laboratory technicians.
What is the criteria?
Criteria is this, Lordship. Actually, in this case, what happened is petitioner, Lordship, they were initially appointed as a contractual basis in 2019. Contractual basis as a lab.
No, please tell me the criteria, not the history.
Lordship, criteria is that, Lordship, page number 75, Lordship.
In order to be promoted from laboratory assistant to laboratory technician.
Yes. Lordship, criteria, there should be, Lordship, as per our rule, there should.
You are seeking relaxation.
Yes, relaxation, Lordship.
So that means there is a criteria. What is the criteria?
Criteria is that, Lordship, our rule is that, Lordship, at least 50% of this relaxation should be as in the hand of the department, and the next is 50% is Government of Arunachal Pradesh. So in my department, Lordship, we are serving lab assistant from the year 2009 to 10, all to 10 now 18, 19 years, Lordship. So what happened, Lordship? In 2017, Lordship, the department has made regulation of our lab assistant as a regular that's a force, Lordship. So after that, what happened? Among them, our that's employee, Lordship, page 17, I have clearly mentioned that, Lordship, para 9,
Among the lordship, our that's employee, 4 of the person has been promoted to the lab technician from the lab assistant. We are the same batch, everything is same. But lordship, through the RTA, we came to know that our friends, as 4 of friends has been already promoted to lab technician from the lab assistant. So here, lordship, in page 75, I have clearly mentioned in my representation, lordship, the remaining post of lab technician has been filled in the appropriate manner. Now we came to know from the information under RTA that other 4 persons, namely Kalung, Rade, Hage, Jumpi, have been regularized, promoted to the post of lab technician by counting the first service as a contractual employee. Whereas as per record, they were serving in the department for 8 years as a contractual employee and not eligible to be appointed as regularized as lab technician unless first service as a contractual employee is not counted. By adopting such procedures, the government has already given relaxation to the similar situated case. However, despite of repeatedly representation for similar consideration, the various representation are lying pending till that. So our friend, similar friend has been lordship appointed that lab assistant to the lab technician. So on the view of that lordship, we have submitted this representation to consider our prayer to implement the same lordship as per the other rule, lordship.
You still have not answered my query. What is the criteria for promotion to lab
Criteria is,
technician?
lordship, promotion criteria is that there should be to at least promote that lab assistant to the lab technician.
You have a recruitment rules?
Lordship. Lordship, just recruitment.
See, the basis of your claim to get promotion to lab technician is that some other persons have been given promotion. I also should be considered by counting my past service.
Yes, lordship.
Only that.
So, lordship.
So that cannot be the reason. Somebody has been wrongly promoted cannot mean that you should also be wrongly promoted. So that is why I'm asking you, what is the criteria as per the rules, as per the recruitment rules? You're not able to understand what I'm saying.
Lordship, actually, lordship, lordship, that's my sum of page has been missed, lordship. So I better me fix tomorrow, lordship.
Will not be fixed tomorrow. We'll adjourn it for 1 week or 2 weeks. You've been adjourning it for the last 2 days.
Monday, lordship, fix it Monday.
Monday is a holiday.
Tuesday, lordship.
Has paid for list on 16th of December.
Item number 2.
Marvelous, my lord. Finally, my lord, this is the same matter, my lord, which I have been hankering since yesterday, my lord.
Same matter.
My lord, this item number 2 and 3 is almost, my lord, same. There is only, my lord, in this intent.
What kind of same matter is this?
Here against the NIT. First of all, I will take the lordship to the page number 51, my lord. This is the NIT which I am challenging before the last, my lord. This NIT, my lord, 51 in Excel M, my lord. Here, my lord, the name of work is the, my lord, construction of ORs, accommodation for the 2 nodes of Jovan Brack at the Maja Pop of the 10 BN Kimin. My lord, kindly note it, balance work, my lord. And my lord, this NIT is supposed to be opened by my lord at 4 today, my lord. We are now in the 3, my lord. Bid opening date is 12/10/2025 at my lord 16 hours. My lord, the opening has not bid has not been opened yet, my lord. Why I am challenged, my lord? Why I am against this case, my lord? I'll take back to the lordship to page number 23. This is the same work. In Lecture 1, page 23, my lord. Construction of works, my lord, accommodation for the Raja Bob of 10 BN ITBP Kimin, my lord. This advertise was made on, my lord, in years 2023, and accordingly, I am the successful bidder, my lord. Now, out of this balance works has been, press and it has been called for. And Lordship may kindly come to page number 25. This is the acceptance letters to me by the, my lord, respondent authorities. Acceptance of the tender works, construction of the OR's living accommodation of the Maja BOP of 10 BN Jimin ITBP, my lord. And accordingly, my lord, my performance guarantee was also submitted. And in the next page, Lordship will find the work order was issued to me on 16/12/2023. This work order was issued. Thereafter, my lord, the next one is the structure. Drawing has been issued to me. And accordingly, my lord, since 2023, I have started the work. And Lordship may kindly come to page number 30 in actually show for the works. Therefore, my lord, this work has been 80% of the work has been completed in this package, my lord. What is remaining is only, my lord, sealing and the, my lord, coloring, my lord. And the others remaining materials I have already accumulated.
Your contract has been terminated?
My lord.
Terminated?
My lord.
By which order?
By, my lord, by the order that, my lord, may kindly see in the page number 42 by 23/7/2025. Before this, my lord, what they said that before come to this, I'll show the lordship to the page number 37. Initially, show cause notice was issued to me. My lord, in page number 37, this show cause notice was issued to me. Dated 20 March 2025.
And one more?
Then accordingly on 27 March 2025, I have replied and cited the reason why that cannot be, my lord. Why there is certain delay in the works, my lord. And
how many show cause? Two show cause.
My lord. One, my lord. One for this.
Page 42, Annexure J speaks about 2 show cause notices.
My lord, I'm in page number 47, my lord. Thereafter, my lord, I have received this show cause notice of that page number 37.
No, please come to page 42.
My lord.
Please come to page 42. Notice of final action under clause 3 of the agreement. The first paragraph, the last line.
My lord, first paragraph of the last line.
Second last line. Whereas you were served with show cause in the start under office letter number 25/4/25 and 23/20/25. But no reply has been given by you so far.
My lord. And my reply has, my lord, in the last page. My lord, I have received the show cause notice of the 23/2025. I have not received the earlier one, my lord. And my lord, in page number.
It is not the earlier one, it is the later one.
Yes, my lord, later on.
25/4.
That 25/4 show, I have not received, my lord. So, my lord, I have replied on. Replied to this
therefore,
27.
Under powers delegated to me under subclass so and so, the undersigned engineer in charge of the forces work of agreement hereby determine the contract as upon so and so. Shall stand absolutely forfeited and shall be absolutely at the disposal of the government. So it has been forfeited. This is 23/5/2025.
This is the 23/5/2025.
You did not receive this notice of final action earlier?
No, my lord.
When did you receive?
I was, my lord, on receipt of this, my lord, I have filed a representation. So exact date, my lord.
So you have come in the last minute, although this notice of final action was given to you in the month of May, 23rd May 2025.
My lord, to that extent, my lord, it is true.
And now you're coming last moment. Why?
And my lord, by the representation, my lord, I have cited the region, the same region, my lord, that I have replied in the show cause notice. So, my lord, what was making me delay is, my lord, not because of my negligence, but it was because of the intervention of the respondent authorities. On the, my lord, December 2024, when my work is almost at the verge of, my lord, completion, they interfere me by saying that the certain drawing has been changed. Therefore, my lord, I was asked to wait for. And for the reason I have been wait for the last, my lord, this last 1 year. And accordingly, my lord, I have written the application to the, my lord.
See your
As
contact.
to why I should not be punished to the, my lord, that
See, at this moment,
changes of drawing, my lord.
at this moment, we can only issue notice. Don't expect anything beyond that. See, notice was given to you in the month of May. You submit a representation in October 20. And now when they are advertising NIT again,
This NIT
you come to the court. Hmm?
My lord, on 15/11/25.
That's what.
So at least, my lord, the bid is not yet been open at this stage, my lord. Therefore, my lord.
So let them open. What is there?
My lord, my prayer would be let the notice be issued at the same time, my lord. Even if the notice is open, my lord, the result may be stand, my lord. Because if the, my lord, this.
Why?
Because if the, my lord, bid is declared, my lord, then my petition will be in process, my lord.
Then you go for civil court and claim damages.
And at the same time, my lord, so far I have executed the 80% of the works, but
Why not 100%?
I have not been payment, my lord.
Why not?
Payment has not been made to me.
Why not 100%? Time given to you is 18 months.
Of course, my
You have
lord.
taken more than almost 2 years.
That is why, my lord, I am submitting that this is not because of my foul, not because of my negligence, but this has been, my lord, delayed by the intervention of the respondent authority, who said that they are changing the, my lord, structure, my lord. And some portion of the works executed has also already been demolished, my lord, in the name of this new structure, my lord. So the new drawing has not been furnished to me till today, my lord.
So if that is your grievance, then why didn't you make your representation or reply to the notice they gave you? Why did you wait till October to reply to the notice given to you in the month of May?
My lord, that is true. That the moment I received the, my lord, this
If it
notice,
is true, then what more can we say?
my lord,
You've taken your own time to do everything, so we can issue notice only. That's all.
my lord, at least I'm praying for, my lord, interim, my lord.
Interim, you can pray, no doubt, but court will not grant you. That's all. Your action speaks for itself. You understand what I'm saying?
My lord.
From day one, if there was a problem, you should have addressed to that immediately. They gave you notice once, twice, you said nothing. And ultimately, they give you a final action notice.
In fact, my lord, I was on the anticipation that at least my
No. After
representation
6
is
months
clear.
again, you reply.
And
That cannot be.
since I was waiting for my lord, the furnishing me the new structure, my lord, the new drawing that they are talking about.
Mr. Kato,
And only notice maybe, my lord, the opening of the tender.
notice and stay?
Not stay, my lord.
Not stay.
Otherwise, my lord, the opening of the bid is, my lord, the final stage after, my lord, several procedures, my lord. So therefore, if
You also tell me, after giving notice of final action in the month of May,
my lord,
why do you go for fresh tender only in November?
maybe, my lord,
In the meantime, what is happening there?
my lord, it requires, my lord, approval from the higher authorities, my lord. It is not, it is a one unit, my lord, the commandant, my lord. So it requires, my lord, several procedures to get approved from the higher authorities, my lord.
How many months? 6 months?
My lord,
It took you 6 months.
admittedly, my lord, it seems, my lord.
So higher authorities approvals require 6 months time.
My lord, however, my lord, if lordship perused again, my lord, the so-called notice, the reason is different, my lord. The reason, my lord, the submission, my lord, if we go by the submission of the Malayalam brain, my lord, it is not because on change of the, my lord, the structure or drawing, my lord. Admittedly, it is well settled position, my lord. The authorities cannot change the game. But however, my lord, the reason for the, my lord, the so-called notice is, my lord, the only delay, my lord. Delay in execution of the work, my lord. So at this stage, my lord, notice, I'll take instruction also, my lord.
But Mr. C. Modi, Learned Counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the NIT dated 15/11/2025. And also the notice of final action under clause 3 of the agreement dated 23/5/2025. Stop. Next para. The Learned Counsel submits that the respondent authorities floated an NIT for construction of OR'(S) living accommodation at Maja BOP of 10th Battalion ITBPM, Kimin, on 20/2/2023 at the estimated cost of 236,44659 with a completion time of 18 months. The petitioner responded to the NIT and his tender was accepted. And ultimately, a work order was issued to him on 16/12/2023. However, despite having completed 80% of the work, the respondent authorities issued the impugned notice on final action under clause 3 of the agreement dated 23/5/2025. Although the petitioner submitted a representation, the same was not considered and a fresh NIT was issued on 15/11/2025. By which the petitioner has been restrained from participation. And the date for opening the bid is 10/12/2025 at 1600 hours. The Learned Counsel for the petitioner submits that the delay in completion of the work was due to the respondent authorities themselves, since they had made the petitioner wait for certain changes in the plan for the construction work. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. M. Kato, Lanet DSGI, accepts notice on behalf of
All the respondents. madam.
all the respondents. Extra copies of the writ petition will be furnished to him within 3 days. List again after 4 weeks. Yes.
And in case of item number 3, my lord, same except, my lord, the amount and the name of the works, my lord.
Huh? What is this? Affidavit in opposition.
Additional affidavit.
Additional affidavit, my lord.
Which I have
My lord, this is the annexure number M, my lord. This is the main.
No, notice is yet to go in your writ petition. How do you file affidavit in opposition? Who has filed it?
No, my lord. Additional, my lord. In fact, my lord, while filing, my lord, inadvertently, my lord, this this NIT was annexed. So this by this additional, my lord, the NIT in question
Give
is
it
my
to
lord.
him. See, this is affidavit in opposition by respondent numbers 1 and 3. This is not your affidavit, I think.
Oh.
Which case is this? 530. 530, see.
Second one is
This is 582.
582. madam.
582.
Why are you giving me that one? Yes, where is the NIT? The first one?
My lord, the same NIT or challenge is, my lord, on the same date, and the NIT, except, my lord, work is different and the amount is different, my lord. Otherwise, my lord, everything is same, my lord. While filing, my lord, this was inadvertently missed my lord, the annexure M. So by filing this additional affidavit, this is the
No, additional affidavit is not with me. You're talking about certain additional affidavit, but it is not here. Copy given to me is affidavit in opposition in another case, not in this case. Now you come to page 23. This is the NIT. The first NIT.
my lord.
Correct?
Yes, 382.
Page 23. Are we holding the same brief? WPC 582.
My lord.
Correct?
Correct, my lord.
Then you come to page 23.
My lord.
This is the first NIT.
This is the, my lord, the verse NIT, my lord.
Dated?
The 22, 2023.
Okay, fine. Now, where's the work order given to you? Page 26?
Yes, my lord.
Correct.
Page 26.
Now, where's the notice?
Page number 35.
How many times they've given you notice?
Well, I have received once.
Only once.
My lord.
You gave a reply?
On page 36, my lord.
You gave a reply on page 36.
My lord.
Thereafter, what have they done?
Thereafter, my lord.
Notice to final action.
My lord.
At page 40.
40, my lord.
Then the fresh NIT.
Press NIT, my lord. And thereafter, my lord, representation was filed. Page 42.
But they have not done anything, isn't it? They've issued fresh NIT now.
My lord.
So it's more or less the same thing.
My lord. This is same thing except, my lord, the name of the work and the amount, my lord.
All right. Please write. Heard Mr. C. Modi, learned counsel for the petitioner, who summons that the petitioner is aggrieved with the notice on final action under clause 3 of the agreement dated 23/5/2025 bracket annexure J and the NIT dated 15/11/2025 bracket annexure M issued by the respondent authorities. Stop, next para. The Learned Counsel submits that pursuant to the NIT dated 22/2023 for construction of OR'(S) living accommodation of Maja BOP of 10th Battalion ITBP Kimin for an estimated cost of 236,44659 with the completion time of 18 months, the petitioner was selected and issued work order on what is the date? Is it 24 or 29? 29, I think. On 29/8/2023. Despite the petitioner having completed, how much have you completed? 80% of the work, a show cause notice under clause 3 of the agreement was issued to him on 23/2025. Although the petitioner replied, a notice on final action under clause 3 of the agreement was issued to him on 23/5/2025 and against which the petitioner submitted a representation on 20/10/2025. Despite the same, the respondents have issued a fresh NIT on 15/11/2025 for the remaining balance of the work, while debarring the petitioner from participating in the tender process. The bid is due to open on 10/12/2025 at 1600 hours. The Learned Counsel therefore submits that, being agreed, the petition is before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. M. Kato, Learned DSGI, accepts notice on behalf of all the respondents. Extra copies be furnished to him within 3 working days.
My lord, one line may kindly aid, my lord, at least my lord till to the outcome of my lord this writ petition, subject to the outcome of the writ petition, my lord.
Okay. Any finalization of the tender process would be subject to the outcome of the writ petition. Same thing in the earlier also. Okay.
Item number 4 and 5.
The ordered method pertaining to the 6 bridges. My lord, I had, in fact, almost concluded. I'll just try to sum up, my lord, by my arguments, my lord. Firstly, my lord, emphasize and the entire reliance by the petitioners is on the UO Note 530 at page 44 of the writ petition, which was a proposal for executing the work by way of an extended tender to be given to the petitioner. That proposal was the proof they submit by the Honorable Chief Minister by endorsing his signature. So once that has been done, the work should have been awarded to them by way of an extended tender.
Yes.
Now, my lord, my argument was that
it is not a cabinet decision what they have argued. It is only a signature of the Honorable Chief Minister. And they have placed nothing on record that there was a cabinet decision taken to award the work through the extended tender, which they have argued. There is nothing on record. They have not produced a single document. Now, I have shown your Lordship the two different sanction orders. Of the same date, one was signed on 18, the other was signed on 19, and corrigendum was issued. In the first sanction order, there is a mention in clause 12, there is a mention of the sentence that the work will be by way of an extended tender as per UO Note 530 of dated so-and-so. This order, the condition for execution was found to be incorrect. So it was corrected, modified, and another sanction order was issued. Same date, but signed on 19 and issued on 21. And corrigendum was issued also on 21. In the second sanction order, my lord will recollect, in clause 12, there is a condition stating that the process of tendering and tendering should be mandatorily followed, my lord. Now, that the argument advanced was that the department officer, the chief engineer, could not have changed the condition, the cabinet decision that it should have awarded the work by way of extended tender to the petitioner, could not have changed by his own unless rooted again through the cabinet. First of all, my argument was it is not a cabinet decision, and they have shown no other document that there was a cabinet decision wherein by way of extended tender, this work has to be given to the petitioner. The only document they have shown is the UO Note at page 44, that which my lord has seen, UO Note 530, where signature of the. Other than that, there is nothing. They have shown that they are entitled to be given the work by way of extended tender. Now, this sanction order, which has been rectified, it talks about the tendering and competitive bidding. There is a terms and condition how the project should be executed. Here in the sanction order itself, it is clearly mentioned that all financial rules have to be followed and tendering and competitive bidding should be followed. Now, this sanction order is not under challenge by the petitioners. This sanction order, wherein the condition is that the work should be executed by tendering and competitive bidding, which we have annexed. This is not under, yes, that is not under challenge. That has not been challenged. This is a condition in the sanction order itself, that the work should be executed through tendering process and competitive bidding. This condition remains to be followed, and they have not challenged this sanction order. Rather, the entire argument they advance is that the work should have been awarded through by way of extended tender. Now, I have already shown, my lord, that two different sanction orders in my affidavit in opposition. The memo numbers are different, my lord. The date, the initial one was, although it is dated 11, but signed on, the first one was signed on 18 March. Then the second one was again, just because there was some error, it was again signed on, rectified sign on 19 March and issued on 21st March. And corrigendum also accordingly issued on 21st March, same day. I will just trouble my lord to take to this annexure just to refresh, my lord. In my affidavit in opposition, only 3 documents are there. I'll just try to clarify the entire thing. At page 127, my lord will kindly see of my affidavit in opposition. Vanessa. Affidavit in opposition in this
Item number 4 and 5.
4 and 5.
What is the stage of the work?
Stage, it is halted.
Halted?
No.
There's a
It
stay
is
order?
yes, it is halted.
Out of 6, 2 projects we are still continuing.
Wow.
2 projects. For 2 projects, they have already executed. They have awarded to us, which we are continuing on the basis of extended tender. Agreement is there. We will be showing.
So the 2 projects, though, I don't think there's any dispute about that. I've seen somewhere, it says that apart from the 2 projects, the other 4 projects should be stopped.
Yes, yes. There was a
2 project is going on.
Going.
But the 4 projects are not.
No.
There's no work on that.
We have done substantial work.
No, that status report is given in page 37 of the second writ petition.
What is the status in respect of those 4 works, 4
Yes,
projects?
my lord, that
bridges.
I have shown to your lordship last time. The first one 95% completed. Second one earthwork excavation and PCCB is completed. Third one side earthwork excavation for open foundation completed. Fourth, there is no work. Fifth one 45% completed. And the 6th one out of 6 numbers, 3 numbers pile foundation of meat pair completed and 1 number 50% completed. This is the position, my lord.
This is from where you're seeing that?
That your lordship will find at page 37 of the second writ petition. There is WPC 346.
346.
Item 5.
The record?
Item 5.
No, okay, that's what I was.
At page 37 and Annexure 4.
Who has given this report?
This is the project engineer, my lord. Your lordship will find assistant engineer Balijan subdivision.
Okay.
He's the project engineer.
So this speaks about the entire 6 bridges.
Exactly.
95% complete artwork, 1 side, no work, 45 completed. And there was something written about the 2 works, 2 bridges in particular.
Yes.
Which may continue, but for the remaining 4, there should be a tender or something like that.
Right. That your lordship.
Can you identify which is the work here?
My lord, these 2, that is number 1, Dokosonala, 95% completed. And then, my lord, 5, serial number 5, that is Jera Nala, 45%.
These are the two works.
These are the two works.
Five.
Yes.
And 1 and 5.
1 and 5.
So apart from 1 and 5, the remaining they say that it should not be done by
It
you.
should be through
It should be
e-tendering.
done by thing.
Well,
Where's that document?
that document, Your Lordship,
Is
will
it
find.
in which writ petition?
Yes, that,
The first one or the second one?
the first one, my lord.
First one.
Your Lordship may kindly see page 75 and 76.
75. Correct. 75.
Yes.
Bridge over Dokoso and Gira Nala.
Yes.
Correct. Dokoso and Gira Nala. Okay.
And B, Your Lordship will find remaining 4 bridges by floating fresh e-tender.
Okay. Now, what is the position? There's a stay order operating?
The
Or
status quo order is there.
status quo?
It's operating.
Which means what? That you'll continue working?
Exactly.
Or you'll continue to stop?
No,
stop.
it's not a question of stopping. Well, status, as Your Lordship has seen.
The status quo interpretation is done by both sides, you see.
My lord, Your Lordship.
One will say status quo means I will continue to work.
My lord.
Opposite party will say status quo means you will not work.
Yes, my lord, in fact, after the status quo, they have not gone ahead with the work.
They have not gone ahead.
Yes, for the remaining 4. And it, as per instruction, they have completed 1. Already completed 1.
Because that time it was 95%.
Yes, yes.
As on April.
The other one is not being, it's not complete, and they are not, they have not executed that work. The second one.
The second one is 45% complete.
Yes.
As on
That also they have not completed.
Let
They
him complete, my lord. My lord, systematically will answer all the
yes.
questions.
So more or less things are come into picture. I think you have all completed. I just had few questions. That's what I just wanted to ask you.
Yes, sir.
How long will you take?
I will not take my time, my lord. Now, my lord, the sanction order talks about the work to be executed by floating tender and competitive bid. This condition is not under challenge. The second contention is that by applying the doctrine of promissory estoppel, this work should be awarded to the petitioner, my lord. Now, my lord, firstly, the very, I have already submitted, there was some connivance between the petitioner and the engineering, the department engineer. Without any approval of the government, straightly rushing for ahead and by intimation to start executing. Especially with due respect, the executive engineer. I will not show, but there has been many ugly correspondences between the chief engineer and the executive engineer. Despite that, the executive engineer, he entered into agreement with the petitioner this for 2 bridges, relying on the same you or not. My lord will kindly say, yes.
You. If you all say that UO note was not in proper form, what prevented you from taking necessary action?
No, that UO note.
No, you don't continue with the work. This UO note is not the right thing. We have to withdraw this. You immediately could have done it. 95% work complete, 45% work complete, then you act.
My lord, in fact, the project was not even sanctioned at that time.
So that's what I'm saying. What remedial steps have you taken?
The project was not even sanctioned. There was a anticipation it might be sanctioned, and project itself was not sanctioned at that point of time. Before even, just because it was approved, they have started rushing. Before the sanction. Before the sanction.
No, understood. Sanction came later on. But going by what you say that these things have not been done in proper thing, the cabinet approval, cabinet approval is required as per these business rules. All these things have not been done. That's why the impugn notice given here is justifiable.
Yes.
This notice you have given in the month of March.
No, prior to that also there were notices.
Approval came, according to them, approval was already there by that EO note on September 2024.
24.
So if something was done unauthorizedly, what prevented you from undoing that?
In fact, yes, something was not done unauthorizedly. What I would say
was not done unauthorizedly.
No,
That means
no, my lord. They went ahead before any approval.
No, that you said, I understood.
Yes.
They went ahead without any approval. They were in a hurry. Maybe they were in hand in gloves or something like that, whatever. But question is, the government is government.
Yes.
Ultimately, they come to know that something is done which is not properly done. You have to withdraw everything. You can't,
Immediately, yes.
Why didn't you take immediate steps?
That's why, my lord, there has been loads of correspondences with by the chief engineer to the executive engineer not to go ahead.
Okay.
There, I will just if the second writ petition, in the second writ petition, they have annexed because it is after various correspondences in the second writ petition, madam. There annexure 2 at page 33, madam. Annexure 2, yes, they have annexed it as to the, my lord will see, have seen.
Yes.
To the executive engineer, it was on 21/1/2025. What the chief engineer is writing to the executive engineer. In the first place, the current work sanction under so and so for so and so and bridges has been termed as phase 2 by your office, albeit the same is not reflected in the nomenclature of the scheme sanctioned by the government, save and except the nomenclature of the flagship program under so and so. That being the case, the terming the current work as phase 2 is misconstrued and misplaced notion which cannot be sustained in the present context.
All right.
In the second place, here, the language of your letter is not in good taste. Nuances of official decorum are not maintained in the said letter. Hence, this office has felt serious. There has been serious correspondence between.
Okay.
So immediately, despite repeated direction to the executive engineer by the chief engineer, the work, he did not issue work to stop, an order to stop the work, my lord. So ultimately, this correspondence was forced to be met by the chief engineer. And my lord, the crux is that whether the executive engineer who entered into contract agreement with the petitioner without any authorization approval from the government, can he enter into a contract with the petitioner? No, he was not even authorized. There was, if my lord will see.
There's an agreement?
Yes, my lord.
Where is that?
That my lord will kindly see in the first writ petition at page 79.
So what do you say about this agreement?
This is also unauthorized, illegal.
Okay.
This agreement itself. And this talks about the sanction order, which, if my lord will see, the sanction order, with reference to sanction order number so and so, the memo number is given 1635 dated so and so. This sanction order, which was cancelled, the executive engineer still proceeds with the sanction order, which was already cancelled. My lord will recollect that sanction order by 1630, this memo, that condition by way of extended tender was there. That was cancelled. Fresh sanction order was issued by way of corrigendum by issuing a corrigendum. Now still, the executive engineer, being hands in gloves, with still continues. This agreement is after that, my lord, in the month of April. Work itself is unauthorized.
My lord, the word hands in glove between contractor and the executive.
I have my liberty to.
No, my lord, this is unsubstantiated allegations. If there at all has been any such unholy nexus, what prevented you from taking action? Please don't make
Yes,
this.
yes, yes.
I request you,
Yes.
please do not make this.
I know.
Because
Let
this
go.
is not good also.
I have my
This is not
liberty
good
to
for
address.
you, not good for me as well.
I have my liberty to address.
Pleaded that.
Yes, yes.
There is no pleading as
No pleading. Beyond the pleading,
I will now. My
general is probably.
and this is the records. Now, my lord, I will show the records. Don't get excited.
I'll just show you lordships within 10 minutes how the government is functioning. We'll let him finish.
Yes. Records, my lord. How the administrative approval and expenditure sanction.
See, it's almost 4 o'clock. You can say it's 4 o'clock. So
I'll just complete in 5 minutes, my lord.
I'll give you 10 minutes.
I'll complete.
Max. Complete that.
Yes, my lord.
And another 5-10 minutes to the opposite party.
Yes,
and
yes.
we're closing it.
Yes.
No more part hut.
Yes. My lord, in the first page, note 1, my lord will see kindly how the administrative approval has to be taken. The e-file note. Note 1, e-file. It's in plain, I believe in plain paper. Certified copies.
Yes.
My lord has seen note sheet 1, my lord. Subject issue of A approval and expenditure. My lord, in the line below, the first page, in view of the fund release as above, an administrative approval to the tune of rupees so and so may be pleased to obtain from the cabinet subcommittee through the honorable advisor Western John, and thereafter file may be endorsed to FD for accord of finance concurrence with expenditure restricted to so and so as per fund provision. Now, in page 3, process has been initiated. Now, page 3, at note 9, continued from previous, an administrative approval to the tune of rupees so and so has been obtained from cabinet subcommittee in a one-go white file, but e-file number so and so, for which a copy of A accorded from CSC is attached in the file at page so and so, underlined at serial number 2 of page so and so, planning department. Hence, proposal may be put up directly to FD, finance department, to accord the finance concurrence to the tune of rupees so and so with an expenditure restricted to so and so as per fund provision. Now, my lord, after this, my lord, I'll travel, my lord, to have the look of the e-file which has been mentioned, e-file number, where administrative approval was in the separate note, note set. This is only for of three pages. The other separate notes here of 3 pages. My lord have seen government of Arunachal Pradesh, so and so is a submission of proposal for obtaining administrative approval from the cabinet subcommittee against the project so and so. Now, this is proposal for obtaining administrative approval from cabinet subcommittee in one go in place of piecemeal manner against the project approved under so and so during the current financial year as for fund allocated by the planning department to the capital circle, Western Zone, so and so. Then, my lord, this particular work finds place in serial number 2, construction of 6 numbers of double lane bridges and ancillary works on Itanagar Jotter Road, so and so, Doimuk. Amount is mentioned, it's so and so, so and so. Now, in the next page, this proposal is put up in view of the limited time limit. The approval above proposal is urgently required to obtain a for CSC from the CSC Cabinet Subcommittee for further submission of individual scheme to obtain finance concurrence on the time-bound manner, please. Then this has been e-file was routed. It was signed by the principal secretary, then the advisor, then approved by the finance deputy chief minister, who is the finance minister also, then the honorable chief minister. After this, the approval was given. This is the approval for administrative sanction and expenditure, administrative approval and expenditure sanction. Now after, I'll again take back to the earlier note sheet, my lord. This is how. There is nothing like any condition for e-tendering is there. Then my lord will kindly see that at page, this was sent, then at page 10, note 37. This is sent by the, it's all routed through e-file, by the Finance and Planning Department. Then here the Finance Department concurs to for financial sanction, my lord. Finance Department concurs to an amount of so and so, with the following stipulated conditions. My lord will kindly say these are the conditions given by the Finance Department while sending it to the PWD department. Then in the Finance Department, in the next page at serial number 12, the same terms and condition. My lord will kindly see the execution of work so and so, all financial rules. Then the process of tendering and competitive bidding should mandatorily be followed and complied with as envisaged in the GFR, DFPR, financial rules and regulations and the conditions, guidelines, circulars and directives issued prescribed by the Government of India, CBC and Government of Arunachal Pradesh in this regard. This was given by the requirement was given and other requirements are also there. This was the requirement terms and condition by the Finance Department. It was sent to the Principal Secretary. Then at page 13, note 39, my lord. DSO be put up for perusal here for signing. This is by the Principal Secretary. DSO means draft sanction order. This is on 11/3/2025. My lord will kindly say. Then these are draft sanction orders. Then at page 14, note 44. Here sanction order is placed below for signature of Deputy Secretary PWD, please. This is by the computer operator. Then, however, at note 48, this is Joint Secretary and Deputy Secretary, JS and DS may both personally see if the draft sanction order is as per FD's concurrence at note 37 and then issue it after ensuring the same. Even the Secretary ensures that it should be as per the terms and conditions of the Finance Department. Then at page 15, note 51, this is important. Note 51, compare the draft sanction order with finance concurrence and given as given at note 37 as directed by authority. DS is also with me. The APSR 2018 is entered in place of APSR 2021 as per the FD concurrence in serial number 4 of the FD concurrence. The second sentence of serial number 12 of FD concurrence relating to mandatory tendering and competitive bidding is also not mentioned. Instead, a different sentence is added. Further details like code so and so are also not mentioned. Please issue order as per FD concurrence to avoid confusion. This was all on 17. Different sentence. 17, this is on 17 March. Then this was again at note 55. Note 55. This is very crucial, my lord. As per instruction given at note 51, sanction order has been modified. Hence, fair sanction order is resubmitted for signature by DS PWD, please. 18. Then this Deputy Secretary at note 56, he signs on at 5 on 18/3/25 at 5:08 p.m. 5:08 p.m. ma'am. Then again, if my lord will kindly see, there is another again taken up 19 in note 60. The Deputy Secretary again sees discrepancies. He again signs same on 19/3 at 4:25 p.m. Deputy Secretary. Then for the corrigendum 60 also. This is nothing. Nothing written, but the timing and date will be important, my lord. The 4:25. Because why? I'll come to that. Because timing also, digital signature, timing also comes up. Then note 64, as per direction of the competent authority referred at note 48 and 51. This is the earlier notes. The earlier sanction order issued by number so and so. The memo number 1635 dated 18/3/2025 has been modified, replaced, and accordingly a fair corrigendum is put up and placed below for signature of Deputy Secretary PWD, please. This is on 20, and then accordingly the fair corrigendum was issued. Letter is placed below for signature at note 67. My lord will kindly say how this word, if my lord will kindly say how it very uniquely, the word that it's the work will be through extended tender, wide you or not. That sentence, how that came into being inserted. Very, very surprising, my lord. To what extent things are being done, my lord. In any case, this was immediately rectified. And what is the condition? That is the finance department's condition while giving the finance concurrence that this work should be executed through e-tendering, through tendering process.
Extended.
Not extended, to tendering process by, and competitive bidding. From where they have said that it should be by way of extended tender. Though this the earlier cancelled sanction order has not been annexed, but the entire argument advanced is only on that basis, that it should have been by way of an extended tender, which itself the foundation is totally wrong. And then the concept of applying the doctrine of promissory estoppel, that will be that can be applied only if the promise is legal. The promisor is acting in his legal capacity, not acting illegally. The state assurances or promise or activities of its officers. In this case, the executive engineer was not authorized even to enter into the agreement, but he had entered into the agreement for 2 bridges. That's all, my lord. Obvious.
My lord, first of all, my lord, I'll take your lordships because my learned friend has said that this number 530 is not relating to the approval of the chief minister. My lord, I'll take your lordship once again. Your lordship may kindly come to page 44, my lord. My lord, your lordship will find in the left-hand side, UN number 530 dated 17/9/2024. And the bottom, your lordship will find Honorable Chief Minister has approved. Now, the law is, my lord, I don't know why my learned friend has said that the approval of Chief Minister is not the approval of the item because, my lord, I took your lordships to a decision of the Appeals Court where in paragraph 71, my lord, their lordship has said, after the concurrence of the Finance Department, the proposal has to be placed before the Council of Ministers and or the Chief Minister. Now, since it was placed before the Chief Minister, he is approved. So therefore, my lord, I do not know how the Additional Advocate General can say that it was not approval of the Chief Minister. Now, this note, my lord, noting was crystallizes into, my lord, executive order, which your lordship will find at page 127 of the other side, the file in affidavit. Your lordship kindly see that. At page 127. In the top, your lordship will find this number is important, my lord, 1635. My lord, he said that has been cancelled. I will show that it is not. 1635. Then, my lord, your lordship kindly see clause 12. The execution of works, schemes, projects, and procurement of so and so should be done strictly as per the provision of GFR, DFR, CPWD manual. All the financial rules, regulations, so and so guidelines directed to the Government of India, Ministry of Finance, so and so, from time to time should be followed in letter and spirit without fail. Now, these 2 lines is very important. The work shall be carried out through extended tender as per approval of the government. White number 530 dated 17/9/2024. Now, my lord, I will take your lordships at page 70 of the first rate petition. Page 70, my lord. The corrigendum, your lordship will strangely find the corrigendum is dated 21/3/2025. And this is the technical sanction given by the chief engineer on 25/3/2025. The mode is the extended contract, my lord. Your lordship kindly see at page 70. In exercise of powers delegated under para so and so, technical sanction is hereby accorded to the work construction of 6 numbers double lane bridges and ancillary works on Itanagar Jyoti Road for an amount of rupees so and so. The administrative approval and expenditure sanction for a total project cost of rupees so and so by the government, white number so and so. Number is 1635 dated 11/3/2025. It is issued by the chief engineer dated, your lordship will find 25/3/2025.
This is much after the corrigendum. Much after the.
This is much after the corrigendum. Then your lordship kindly see at page 72. My lord, the top is written in the middle part, history. At page 72. As your lordship found it, the administrative approval and expenditure sanction has been accorded by the government white number PWD so and so. Your lordship kindly see. Number is 1635 dated 18/3/2025 for amounting rupees so and so. Then your lordship turn to the next page at page 73. In the middle portion, your lordship will find method. through extended tender. And it is signed by the chief engineer dated 25/3/2025, much after the corrigendum. Now, this is the game they are playing. Now, my lord, your lordship, kindly see once again their affidavit, my lord. Your lordship, kindly see at page this is the crux of the entire thing, my lord. Then your lordship may see
Affidavit, their affidavit.
in their affidavit, affidavit in opposition by the state,
129.
page 129. Is a corrigendum, my lord. 129.
Affidavit in opposition.
Affidavit in opposition.
One 129, your lordship will find the administrative approval and expenditure sanction number so and so, ancillary works on Itanagar Jyoti Road under so and so with an estimated cost of rupees so and so, cancelled due to the presence of some unintentional errors. Then now a new administrative approval and expenditure sanction order is issued. White number so and so. Number is my lord 1965 dated 21/3/2025, replacing, superseding the above mentioned order. Now, this is the corrigendum they are harping on, dated 21/3/2025, and then what they have.
Just we are doubting that why it was initiated from different file.
And your lordship knows, my lord, when we make something new, corrigendum or a clerical correction and all that, it is routed through the original file. That is the file issued by the chief engineer. That earlier I have shown 1635. Now it is not routed through that file. Now these are that's why, my lord, I told initially on the day one that these are required to be placed before the cabinet. Whether it was ever placed before the cabinet, it was never. Then, my lord, your lordship, see what is the corrigendum, what they have amended at page 130. Clause 12. This is the game they are trying to play with everybody and even with the Honorable Court also. Clause 12, the execution of works. Now I am skipping all this. In somewhere your lordship will find in the bottom the process of
fourth line.
Tendering, fourth line from the my lord. Your lordship has seen. Well, your lordship will find the process of tendering and competitive. They started from here. Now then I am skipping this. Your lordship may turn to page 131.
Next page.
Your lordship will find down below digitally signed by so and so dated 19/3/2025. Now, if it is a, my lord, corrigendum you are making, it cannot be after the corrigendum dated 21/3. It is 25. Maybe on that date or maybe after that date. But this gentleman has signed on 19/3/2025. Apart from that, my corrigendum, generally what happens, as your lordship is aware, is section 152 of CPC, the clerical mistake, if there is an error in the judgment, the clerical mistake, the corrigendum is issued and that correction is done. My lord, to that effect, my lord, I'll just take an appeals court decision. My lord, I read it just a short para. Up there, well, para 7 point, I'll just slowly read. Well, how the government is functioning, I do not know. Even the Jesus Christ also cannot save them. My lord, paragraph 7.2. It is vehemently submitted by the learned counsel that the impugned order below, note for speaking to the minutes, is as such can be said to be wholly without jurisdiction in as much as order could not have been passed on the note of speaking to the minutes. It is vehemently submitted by the learned counsel that an application for note for speaking to the minutes is required to be entertained only for the limited purpose of correcting the typographical error or an error through oversight, which may have crept in while transcribing the original order. It is submitted that as such, the impugned order on the note for speaking to the minutes is virtually modifying and or reviewing the earlier order passed in the first appeal. Now, what happened here, my lord? Your lordship is fine. The mode was by virtue of extended contract, and it has been in vogue for a long, long time. It's not for the first time. And now they want to say that by making an corrigendum, it's a certain unintentional error, therefore we are amending it. By making an amendment, you are substantially, my lord, changing the terms of the contract. Now, if you do it, you may have the power, but then you will have to place it properly. It should go before the cabinet. Cabinet will give the sanction. Now, where is that? That's why, my lord, I requested them to process the file and place it before your lordships. What they have done, they have certified. Now, your lordship has seen, I have given yesterday, that section 65B of earlier Evidence Act and now 63 4C of the BSA, my lord, it prescribedly shown, my lord, in what way the certificate should be given. And if you do not give that way, my lord, it is not admissible in evidence. So the paper shown to your lordship, these are all photostat copy, and it's not required to be seen at all. Now, another, my lord, crux of the thing is your lordship may see in the note, it is given by the chief engineer that it is the contract is in inescapable nature. So taking recourse to 1.5 of the CPWD manual, these works can be given. Your lordship, just a while, your lordship, see this clause. Relying on this clause, my lord, 1.5, works of inescapable nature. Various works of inescapable nature can be classified as under emergent works. These are emergency works which arise all of a sudden and or inescapable nature requiring immediate action that cannot brook any delay, like number Roman 1, your lordship may skip this. Then the next two, Roman 2, other causes like explosion, arson, fire, war, sudden collapse of building, bridge. So it comes under this. So therefore, when it is found that these are in inescapable nature and the bridge is required to be constructed, it was given to them. Now, my lord, they are coming up with a corrigendum. Your lordship has seen what sort of corrigendum is. They're substantially trying to change the, my lord, the terms of the contract and without following the procedure. If you want to change it, it should be done in a proper manner, not in a hush-hush manner. And the chief engineer, even after the corrigendum, as your lordship has seen, even after the corrigendum dated 21/3, the chief engineer himself has signed and given the technical sanction on 25/3/2025, plus substantially agreeing the mode is through extended contract. So therefore, how come this corrigendum, my lord? Should the government function in that manner? And somebody should responsibility. There is no affidavit to that extent. And my learned friend has argued is beyond their affidavit. They have said certain thing and they have argued some other thing. And can you take us by surprise? You are filing certain things, you are not filing an affidavit. And that judgment the other day I have given to your lordship, that is my lord Arjun Patinder, that has been very systematically said 65B, unless it is produced before the court in that manner, is not an evidence at all. It cannot be admissible.
Because it does not come in the form of affidavits.
Then it ought to have been come in the form of affidavit. They did nothing. And another, my lord, your lordship also required to see clause 12. By virtue of clause 12 of the contract terms, it was given an extended contract. My lord, that also I'm submitting before your lordships for your lordship's adjudication. और कुछ है क्या बोलने का?
All right.
So, my lord, these also your lordship may look at, because in the file noting, your lordship will find they have relied on clause 12 of the original terms of contract.
Okay. We'll
My
close
lord,
it.
much obliged to your lordship.
Much obliged. You there? Heard Mr. S. Datta, Learned Senior Counsel, assisted by Mr. P. D. Tara for the petitioners. Also heard Mr. N. Ratan, Learned Additional Advocate General, Arunachal Pradesh. Hearing concluded, judgment is reserved.
Obliged.
Obliged.
Lordship, next item.
This will have to go some other time.
Tomorrow, man.
I have finished my arguments completely.
My lord, it will not take much time because only the principle has to be determined, that's all.
Tomorrow. Okay, item 6 to 8, isn't it?
6 to 8, man.
It's a
That's great.
first item, my lord,
Tomorrow.
admission column.
Let us see, take your chance. First, we'll have a division bench.
I understand.
After,
Yes.
only we'll come up with this.
Otherwise, after break.
We'll take a chance tomorrow, man, if time permits.
6 to 8.
Yes.
Then you have got the thing, no?
That's the first
Again
item.
tomorrow. As the first item in the admission column. Then item 11 also we can close.
Obliged.
Yes, your lordship can close that, my lord, because I finished my
Item
argument.
11.
All that your lordship said.
Item 11, my lord, CD was called for, my lord.
Give it to your
You have it?
Yes, my lord.
You have it?
Yes, my lord.
So your lordship may peruse. I have no further arguments, my lord. We have both. My impression is she filed at all. In either of the FIR, no charge sheet.
This is sent to us chamber. This is give me the file. 11. So we're closing item number 12 also.
11.
Sorry, 11.
Yes, ma'am.
Please, this is the what? Case diary.
My case diary, my lord.
Updated case diary.
Yes, my lord.
Okay. Please write her, Dr. Colin Gonsalves, Learned Senior Counsel, assisted by Ms. Sunny Tayan for the petitioner through RBC. Stop also heard Mr.
L. Kurdu, my lord. SPP SIT.
L. Kurdu, Learned Special PP, SIT, appearing for respondent number 4, and Mr. M. Kato, Learned DSGI, for respondent numbers 2 and 3.
My lord.
Hearing concluded, judgment reserved.
Grateful, my lord.
May I please, lordship? Lordship, in item number 17 and 18, consent was not taken by me. My consent was not taken in item 17 18, lordship. It was mentioned and it was taken adjournment for 4 weeks. 17 18.
I see.
Yes, lordship. So, lordship, we had filed one IA for injunction, and today was fixed for hearing. I mean, not exactly hearing, but they were supposed to file their affidavit. They did, lordship. But lordship, they mentioned the matter without even taking the.
Who had mentioned it?
I mean, I believe GA, lordship, and the previous counsel was present here, lordship. The previous counsel. Yes, lordship. Maybe there was some confusion.
No, Taba Topu said he's no longer representing.
Yes, lordship. I'm the new counsel, lordship. For the petitioner, lordship.
Okay, but you were not there, no? Even when.
Yes, Lordship, but they did not inform me that they were going to mention the matter, Lordship. And today was for IA, injunction. We had filed one IA for injunction, Lordship. Lordship.
Who has taken the order? You have taken, no?
Mona was there.
This matter may be listed again tomorrow. If
Not tomorrow, we'll have it next week.
Lordship, this is for injunction, Lordship. The respondents, the private respondents, they are cutting
No,
down
it's
trees.
not possible tomorrow, Mr. Counsel. Please understand.
Day after tomorrow, Lordship, then.
No, otherwise the order will remain. We had already passed an order.
Item number 16.
Then, Lordship,
We'll come up in the next week.
Item number 16.
I'll modify the order, okay? Okay. 16.
Yes.
Mr. Counsel, what is your name?
E Payang, Lordship. Eddie Payang, it's there in the cause list.
Oh, E Payang.
Yeah, E Payang and R Yakang.
The other one is not there.
Radhe Yakang. It should be there, Lordship.
Government advocate was there.
R Yakang.
Yeah, R Yakang.
Both of you are there.
Yes, Lordship.
I see.
Lordship, we were not informed that otherwise. Lordship.
It's okay. We'll modify the order. We'll have it next week, Tuesday.
Tuesday? That's it. Deeply obliged.
Yes, what about this?
Lordship, we have filed our affidavit here, Your Lordship. Petitioner has to file rejoinder. For the state government.
Yeah, respondent number 4. Who's respondent number 4? 4 has not filed affidavit.
4 is the private respondent, Lordship.
State has filed.
Yes, state has filed.
Who's for the petitioner?
Dicky Pangin.
None appears for the petitioner when the matter is called. Mr. Payang, Dicky Panging is there. D. Panging.
Yes, he was there.
Where is he gone? None appears for the petitioner when the matter is called. Ms. R. Basar, Lanet State Council appears for respondent numbers 1, 2, and 3 and submit that they have already filed counter affidavit. Next para in view of work, let the matter be listed again after 2 weeks on a date to be fixed by the registry. Petitioner may file rejoinder affidavit. In the meantime, you so advised.
Obliged.
Item number 21.
After vacation, my lord.
Okay, as paid for by the parties, list the matter again after the ensuing winter vacation. 22 also?
22, we are not available.
Item number 22.
None appears for the petitioner when the matter is called. List again after 3 weeks. I require this cost list.
Yes.
Send me the cost list.
Should I set that CD also along, which was that CD?
Oh, definitely.
Okay, sure.
It is.
Yes, sure. Okay, sure. Sure.